Test 1, 2.
Oh, I think.
Right.
I'll go ahead. If you want to give them
Yep.
tests here, I'll give
All
them
right.
tests.
Let me know. Yep. Yeah. Test 1, 2, 3. Test 1, 2, 3. Test 1, 2, 3. Test 1, 2, 3. You're good?
Testing from the dais. Testing. Can you guys hear? Yes. Okay.
Test 1, 2, 3. Testing from the witness table. 1, 2, 3. Testing 1, 2, 3. Testing. Last mic from the witness table. Testing 1, 2, 3.
For the
Microphone
intelligence
check.
hearings.
1, 2, 3, 4,
So the
5,
witnesses
6,
will
7.
come in,
Testing
you'll
1,
all
2.
have-
Microphone check. 1, 2, 3,
So
4,
once you
5,
hear
6,
us
7,
say,
8, 9,
"Get
10.
back,
Testing
everybody
1, 2,
down,"
3,
the
4,
TV
5.
cameras will go to
Microphone
the
check.
sides.
Testing.
Testing 1, 2, 3. Is that better or worse? It's too loud. Testing 1, 2. Is it better? Is it better? Can you hear? Okay. Okay, audio testing, 1, 2, 3, 1, 2, 3, 4. Can you hear? Is that better?
That's perfect.
That's good. Testing 1, 2, 3. Testing 1, 2, 3, 4. How's that? Better? Better? Okay.
What? Yeah. This is the grand room. I was wondering whether this room was created. The House Committee on the Judiciary will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time.
Mr. Chairman, reserving the right to object.
Objection is noted.
I reserve the right to object.
Gentleman is reserved.
Mr. Chairman, pursuant to Clause 2J1 of Rule 11, I am furnishing you with a demand for minority day of hearings on this subject, signed by all of the Republican members.
The gentleman will suspend. I could not understand what you were saying. Just repeat it more clearly.
Pursuant to Clause 2J1 of Rule 11, I am furnishing you with a demand for a minority day of hearings on this subject, signed by all of the Republican members of the committee, and I would request that you set this date before the committee votes on any articles of impeachment.
It's a motion.
I withdraw my reservation.
We will confer and rule on this later. A quorum is present. This is the first hearing. This is the first hearing we are conducting pursuant to House Resolution 660 and the Special Judiciary Committee procedures that are described in Section 4A of that resolution. Here is how the committee will proceed for this hearing. I will make an opening statement, and then I will recognize the ranking member for an opening statement. Each witness will have 10 minutes to make their statements, and then we will proceed to questions. I will now recognize myself for an opening statement.
Mr. Chairman, parliamentary inquiry. Mr. Chairman.
I have the time for an opening statement. The parliamentary inquiry is not in order at this time. The facts before us are undisputed. On July 25th, President Trump called President Zelensky of Ukraine and, in President Trump's words, asked him for a favor. That call was part of a concerted effort by the President and his men to solicit a personal advantage in the next election, this time in the form of an investigation of his political adversaries by a foreign government. To obtain that private political advantage, President Trump withheld both an official White House meeting from the newly elected president of a fragile democracy and withheld vital military aid from a vulnerable ally. When Congress found out about this scheme and began to investigate, President Trump took extraordinary and unprecedented steps to cover up his efforts and to withhold evidence from the investigators. And when witnesses disobeyed him, when career professionals came forward and told us the truth, he attacked them viciously, calling them traitors and liars, promising that they will, quote, go through some things, close quote. Of course, this is not the first time that President Trump has engaged in this pattern of conduct. In 2016, the Russian government engaged in a sweeping and systematic campaign of interference in our elections. In the words of Special Counsel Robert Mueller, quote, the Russian government perceived it would benefit from a Trump presidency and worked to secure that outcome, close quote. The President welcomed that interference. We saw this in real time when President Trump asked Russia to hack his political opponent. The very next day, a Russian military intelligence unit attempted to hack that political opponent. When his own Justice Department tried to uncover the extent to which a foreign government had broken our laws, President Trump took extraordinary and unprecedented steps to obstruct the investigation, including ignoring subpoenas, ordering the creation of false records, and publicly attacking and intimidating witnesses. Then as now, this administration's level of obstruction is without precedent. No other president has vowed to, quote, fight all of the subpoenas, unquote, as President Trump promised. In the 1974 impeachment proceedings, President Nixon produced dozens of recordings. In 1998, President Clinton physically gave his blood. President Trump, by contrast, has refused to produce a single document and directed every witness not to testify. Those are the facts before us. The impeachment inquiry has moved back to the House Judiciary Committee, and as we begin a review of these facts, the President's pattern of behavior becomes clear. President Trump welcomed foreign interference in the 2016 election. He demanded it for the 2020 election. In both cases, he got caught. And in both cases, he did everything in his power to prevent the American people from learning the truth about his conduct. On July 24th, the special counsel testified before this committee. He implored us to see the nature of the threat to our country. Quote, "Over the course of my career, I have seen a number of challenges to our democracy. The Russian government's effort to interfere in our elections is among the most serious. This deserves the attention of every American." Close quote. Ignoring that warning, President Trump called the Ukrainian president the very next day to ask him to investigate the president's political opponent. As we exercise our responsibility to determine whether this pattern of behavior constitutes an impeachable offense, it is important to place President Trump's conduct into historical context. Since the founding of our country, the House of Representatives has impeached only 2 presidents. A third was on his way to impeachment when he resigned. This committee has voted to impeach 2 presidents for obstructing justice. We have voted to impeach 1 president for obstructing a congressional investigation. To the extent that President Trump's conduct fits these categories, there is precedent for recommending impeachment here. But never before in the history of the Republic have we been forced to consider the conduct of a president who appears to have solicited personal political favors from a foreign government. Never before has a president engaged in a course of conduct that included all of the acts that most concerned the framers. The patriots who founded our country were not fearful men. They fought a war. They witnessed terrible violence. They overthrew a king. But as they met to frame our Constitution, those patriots still feared one threat above all: foreign interference in our elections. They had just deposed a tyrant. They were deeply worried that we would lose our newfound liberty, not through a war. If a foreign army were to invade, we would see that coming, but through corruption from within. And in the early years of the Republic, they asked us, each of us, to be vigilant to that threat. Washington warned us, quote, "to be constantly awake, since history and experience prove that foreign influence is one of the most baneful foes of Republican government." Adams wrote to Jefferson, quote, "As often as elections happen, the danger of foreign influence recurs." Hamilton's warning was more specific and more dire. In the Federalist Papers, he wrote that the, quote, "most deadly adversaries of Republican government," unquote, would almost certainly attempt to, quote, "raise a creature of their own to the chief magistracy of the Union." In short, the founders warned us that we should expect our foreign adversaries to target our elections, and that we will find ourselves in grave danger if the president willingly opens the door to their influence. What kind of president would do that? How will we know if the president has betrayed his country in this manner? How will we know if he has betrayed his country in this manner for petty personal gain? Hamilton had a response for that as well. He wrote, "When a man unprincipled in private life, desperate in his fortune, bold in his temper, possessed of considerable talents, known to have scoffed in private at the principles of liberty, when such a man is seen to mount the hobby horse of popularity, to join the cry of danger to liberty, to take every opportunity of embarrassing the general government and bringing it under suspicion, it may justly be suspected that his object is to throw things into confusion, that he may ride the storm and direct the whirlwind." Ladies and gentlemen, the storm in which we find ourselves today was set in motion by President Trump. I do not wish this moment on the country. It is not a pleasant task that we undertake today, but we have each taken an oath to protect the Constitution, and the facts before us are clear. President Trump did not merely seek to benefit from foreign interference in our elections. He directly and explicitly invited foreign interference in our elections. He used the powers of his office to try to make it happen. He sent his agents to make clear that this is what he wanted and demanded. He was willing to compromise our security and his office for personal political gain. It does not matter that President Trump got caught and ultimately released the funds that Ukraine so desperately needed. It matters that he enlisted a foreign government to intervene in our elections in the first place. It does not matter that President Trump felt that these investigations were unfair to him. It matters that he used his office not merely to defend himself, but to obstruct investigators at every turn. We are all aware that the next election is looming, but we cannot wait for the election to address the present crisis. The integrity of that election is one of the very things at stake. The President has shown us his pattern of conduct. If we do not act to hold him in check now, President Trump will almost certainly try again to solicit interference in the election for his personal political gain. Today, we will begin our conversation where we should, with the text of the Constitution. We are empowered to recommend the impeachment of President Trump to the House if we find that he has committed treason, bribery, or other high crimes and misdemeanors. Our witness panel will help us to guide that conversation. In a few days, we will reconvene and hear from the committees that worked to uncover the facts before us. And when we apply the Constitution to those facts, if it is true that President Trump has committed an impeachable offense or multiple impeachable offenses, then we must move swiftly to do our duty and charge him accordingly. I thank the witnesses for being here today. I now recognize the ranking member of the Judiciary Committee,
Mr. Chairman.
the gentleman from Georgia, Mr. Collins,
Mr.
for his opening statement.
Mr. Chairman, may I make a parliamentary inquiry before you?
The gentleman is not in order for parliamentary inquiry. I have recognized the ranking member for an opening statement.
I thank the chairman. And it is interesting that, again, parliamentary inquiries, and I believe some are actually some of the things I'm going to discuss today because we're sort of coming here today in a different arena. Look, for everybody who's not been here before, this is a new room, it's new rules, it's a new month. We've even got cute little stickers for our staff so we can come in because we want to make this important. And this is impeachment because we've done such a terrible job of it in this committee before. But what's not new is basically what's just been reiterated by the chairman. What's not new is the facts. What's not new is it's the same sad story. What's interesting, even before I get into my part of my opening statement, is just what was just said by the chairman. We went back to a redo of Mr. Mueller. We're also saying, quoting him, saying the attention of the American people should be on foreign interference. I agree with him completely, except I guess the American people did not include the Judiciary Committee because we didn't take it up. We didn't have hearings. We didn't do anything to delve deeply into this issue. We passed election bills, but did not get into the in-depth part of what Mr. Mueller talked about, taking his own report and having hearings about that. We didn't do it. So I guess the American people doesn't include the House Judiciary Committee. You know, we also just heard an interesting discussion. We're going to have a lot of interesting discussion today about the Constitution and other things, but we also talked about the founders. What's interesting is that the chairman talked a lot about the founders from the quotes, and again, this is why we have the hearing, about the founders being concerned about foreign influence, but what he also didn't quote was the founders being really, really concerned about political impeachment because you just don't like the guy. You haven't liked him since November of 2016. The chairman has talked about impeachment since last year when he was elected chairman, 2 years ago, on November 17th, before he's even sworn in as chairman. So don't tell me this is about new evidence and new things and new stuff. We may have a new hearing room, we may have new mics, and we may have chairs that aren't comfortable, but this is nothing new, folks. This is sad. So what do we have here today? You know what I'm thinking? I looked at this, and what is interesting is there's two things that have become very clear. This impeachment is not really about facts. If it was, I believe the other committees would have sent over recommendations for impeachment. No, they're putting it on this committee because if it goes badly, I guess they want to blame Adam Schiff's committee and the HIPC and others want to blame this committee for it going bad. But they're already drafting articles. Don't be fooled. They're already getting ready for this. We've already went after this with the Ukraine after numerous failings of Mueller, Cohen, annulments, emoluments, the list goes on. But the American people are actually failing to see us legislate. But if you want to know what's really driving this, there's two things. It's called the clock and the calendar. The clock and the calendar. Most people in life, if you want to know what they truly value, you look at their checkbook and their calendar. You know what they value. That's what this committee values. Time. They want to do it before the end of the year. Why? Because the chairman said it just a second ago. Because we're scared of the elections next year. We're scared of the elections that we'll lose again. So we've got to do this now. The clock and the calendar are what's driving impeachment, not the facts. When we understand this, that's what the witnesses here will say today. What do we have here today? What is really interesting over today and for the next few weeks is America will see why most people don't go to law school. No offense to our professors. But please, really, we're bringing you in here today to testify on stuff that most of you have already written about, all four, for the opinions that we already know, out of the classrooms that maybe you're getting ready for finals in, to discuss things that you probably haven't even had a chance to say, unless you're really good on TV or watching the hearings for the last couple of weeks, you couldn't have possibly actually digested the Adam Schiff report from yesterday or the Republican response in any real way. Now, we can be theoretical all we want, but the American people is really going to look at this and say, huh? What are we doing? Because there's no fact witnesses planned for this committee. That's an interesting thing. Frankly, there's no plan at all except next week an ambiguous hearing on the presentation from the HIPC, the other committee that sent us the report, and Judiciary Committee, which I'm not still sure what they want us to present on, and nothing else. No plan. I asked the chairman before we left for Thanksgiving to stay in touch. Let's talk about what we have because history will shine a bright light on us starting this morning. Crickets. Until I asked for a witness the other day, and let's just say that didn't go well. There's no whistleblower. And by the way, it was proved today that he's not or she's not afforded the protection of identity. It's not in the statute. It's just something that was discussed by Adam Schiff. We also don't have Adam Schiff, who wrote the report. He said yesterday in a press conference, I'm not going to. I'll send staff to do that. He's not going to, but to me, if he was wanting to, he'd come begging to us. But here's the problem. It sums it up very simply like this. Just 19 minutes after noon on Inauguration Day 2017, the Washington Post ran the headline, "The campaign to impeach the president has begun." Mark Zadd, who would later become the attorney for the infamous whistleblower, tweeted in January 2017, "The coup has started. The impeachment will follow ultimately." And in May of this year, Al Green says, if we don't impeach the president, he'll get re-elected. If you want to know what's happening, here we go. Why did everything that I say up to this point about no fact witnesses, nothing for the Judiciary Committee, which spent 2.5 weeks before this hearing was even held under Clinton, 2.5 weeks, we didn't even find your names out until less than 48 hours ago. I don't know what we're playing hide the ball on. It's pretty easy what you're going to say. But we can't even get that straight. So what are we doing for the next 2 weeks? I have no idea. The chairman just said an ambiguous hearing on the report, but nothing else. If we're going to simply not have fact witnesses, when we are the rubber stamp hiding out back, the very rubber stamp the chairman talked about 20 years ago. What a disgrace to this committee. To have the committee of impeachment simply take from other entities and rubber stamp it. You see, why do the things that I say matter about fact witnesses and actually hearing and actually having this a due process? Because, by the way, just a couple of months ago, the Democrats got all sort of dressed up, if you would, and says, we're going to have due process protection for the president and good fairness throughout this. This is the only committee in which the president would even have a possibility. But no offense to you, the law professors. The president has nothing to ask you. You're not going to provide anything he can't read. And his attorneys have nothing else. Put witnesses in here that they can be fact witnesses who can be actually cross-examined. That's fairness, and every attorney on this panel knows that. This is a sham. But what I also see here is quotes like this. There must never be a narrowly voted impeachment or an impeachment supported by one of our major political parties or imposed by another. Such an impeachment will produce divisiveness, bitterness in politics for years to come and will call into question the very legitimacy of our political institutions. The American people are watching. They will not forget. You have the votes, you may have the muscle, but you do not have the legitimacy of a national consensus or of a constitutional imperative. The partisan coup d'etat will go down in infamy in the history of the nation. How about this one? I think the key point is that the Republicans are still running a railroad job with no attempt at fair procedure. And today, when the Democrats offered amendments, offered motions in committee to say we should first discuss and adopt standards so that we know we're dealing with, standards for impeachment that was voted down or ruled out of order. When we say the important thing is to start looking at the question before we simply have a vote with no real inquiry first, that was voted down and ruled out of order. So frankly, the whole question of what material should be released and what is secondary, but that's all we discussed. The essential question, and here it is, which is to set up a fair process as to whether the country put this country through an impeachment proceeding. That was ruled out of order. The Republicans refused to let us discuss it. Those are all Chairman Nadler before he was chairman. I guess 20 years makes a difference. This is an interesting time. We're having a factless impeachment. You just heard a one-sided presentation of facts about this president. Today we will present the other side, which it gets so conveniently left out. Remember, fairness does dictate that, but maybe not here because we're not scheduling anything else. I have a Democratic majority who has poll tested what they think they ought to call what the president they think he did. Wow, that's not following the facts. We have just a deep-seated hatred of a man who came to the White House and did what he said he was going to do. The most amazing question I got in the first 3 months of this gentleman's presidency from reporters was this: can you believe he's putting forward those ideas? I said, yes, he ran on them. He told the truth, and he did what he said. The problem here today is this will also be one of the first impeachments. The chairman mentioned there was 2 of them, one that before he resigned before, and then one in Clinton, in which the facts, even by Democrats and Republicans, were not really disputed. In this one, they're not only disputed, they're contradicted of each other. There are no set facts here. In fact, they're not anything that presents an impeachment here, except a president carrying out his job in the way the Constitution saw that he sees fit to do it. This is where we're at today. So the interesting thing that I come to with most everybody here is this may be a new time, a new place, and we may be all scrubbed up and looking pretty for impeachment. But this is not an impeachment. This is just a simple railroad job. And today's is a waste of time because this is where we're at. So I close today with this. It didn't start with Mueller. It didn't start with a phone call. You know where this started? It started with tears in Brooklyn in November 2016 when an election was lost. So we are here, no plan, no fact witnesses, simply being a rubber stamp for what we have. But hey, we got law professors here. What a start of a party. Mr. Chairman, before I yield back, I have a motion under Clause 2, Rule 11.
The gentleman was recognized for the purpose of an opening statement, not for the purpose of making a motion.
I yield back and now ask for recognition for a motion under Clause 2, Rule 11.
The gentleman is recognized.
Mr. Chairman, pursuant to Clause 2 of Rule 11, I move to require the attendance and testimony of Chairman Schiff before this committee and transmit this letter accordingly.
For what purpose does the gentlelady seek recognition? Motion to table is made and not debatable. All in favor of the motion to table say aye. Aye. Opposed?
No.
The motion to table is agreed to.
Recorded vote.
The recorded vote is requested. The clerk will call the roll.
Parliamentary inquiry, Mr. Chairman.
The clerk will call the roll.
Parliamentary inquiry, Mr. Chairman.
You're not recognized for parliamentary inquiry at this time. There's a vote in process.
Just a reminder, any no vote says you don't want
Nadler.
Chairman Schiff coming, correct?
The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia. Mr. Johnson of Georgia votes aye. Mr. Deutsch. Mr. Deutsch votes aye. Ms. Bass. Mr. Richmond. Yes. Mr. Richmond votes yes. Mr. Jeffries. Aye. Mr. Jeffries votes aye. Mr. Cicilline. Aye. Mr. Cicilline votes aye. Mr. Swalwell.
Yes.
Mr. Swalwell votes yes. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Demings. Aye. Ms. Demings votes aye. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse. Aye. Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell.
Aye.
Ms. Mucarsel-Powell votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Collins.
No.
Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler?
No.
Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong?
No.
Mr. Armstrong votes no. Mr. Stubbe? No. Mr. Stubbe votes no.
Has everyone voted who wishes to vote? Ms. Bass?
Ms. Bass votes aye.
The clerk will report.
Mr. Chairman, there are 24 ayes and 17 noes.
The motion to table is agreed to.
Mr. Chairman, I have a parliamentary inquiry.
The gentleman will state his parliamentary inquiry.
Thank you, Mr. Chairman. Clause C2 of the Judiciary Committee's impeachment inquiry procedures states that members of the committee can raise objections relating to the admissibility of testimony and evidence, but it doesn't say what rules apply to admissibility. So I'm hoping you can explain to us what objections may be made under this clause, and if you intend to use the federal rules of evidence.
The gentleman will suspend. That is not a proper parliamentary inquiry.
It is a proper.
It is not a proper parliamentary.
I stated a rule. I stated
Stated a rule, Mr. Chairman. You can ignore it and not answer it, but you can't just say it's not a proper.
I'm asking for the application of the rule for an explanation, Mr. Chairman. I don't know how that's not parliamentary.
We will apply the rules, period.
You won't help us understand that? There's no clarity there.
Which rule are
As I
you
said.
citing? How are you citing that?
Clause C2 of the Judiciary Committee's impeachment inquiry procedures. How's that unclear?
It's the rules of the House, and they will be applied, period. That's the reply.
I'm asking how will they be applied here, sir?
They will be applied according to the rules.
But not answering your question.
A circular response. Thank you. And, Mr. Chairman, can you please also iterate the schedule going forward? In other words,
That
are you
is
planning
not
to
a
hold
parliament-
additional hearings? And if so, when do you
The gentleman will
anticipate
suspend.
releasing or?
That is not a proper parliamentary inquiry. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses.
Mr. Chairman.
Noah Feldman.
Mr. Chairman.
Is the Felix.
Chairman, I seek recognition.
The gentleman is. I am not going to recognize you now. I am introducing the witnesses.
Mr. Chairman, I just.
Noah Feldman is the Felix Frankfurter Professor of Law at Harvard Law School. Professor Feldman has authored 7 books, including a biography of James Madison and a constitutional law casebook, as well as many essays and articles on constitutional subjects. Professor Feldman received his undergraduate degree from Harvard College, a doctor of philosophy from Oxford University, where he was also a Rhodes Scholar, and a J.D. from Yale Law School. He also served as a law clerk to Justice David Souter of the United States Supreme Court. Pamela Carlin serves as the Kenneth and Harl Montgomery Professor of Public Interest Law and the co-director of the Supreme Court Litigation Clinic at Stanford Law School. She is the co-author of several leading case books, including a monograph entitled Keeping Faith with the Constitution, and dozens of scholarly articles. She served as a law clerk to Justice Harry Blackburn of the United States Supreme Court and as a Deputy Assistant Attorney General in the Civil Rights Division of the United States Department of Justice, where she was responsible, among other things, for reviewing the work of the department's voting section. Professor Carlin earned 3 degrees from Yale University, a BA in History, an MA in History, and a JD from Yale Law School. Michael Gerhart is the Burton Craig Distinguished Professor of Jurisprudence at the University of North Carolina School of Law and Director of UNC's Center on Law and Government. Professor Gerhart is the author of many books, including The Federal Impeachment Process, a Constitutional and Historical Analysis, as well as more than 50 law review publications on a diverse range of topics in constitutional law, federal jurisdiction, and the legislative process. He received his J.D. from the University of Chicago Law School, his M.S. from the London School of Economics, and his B.A. from Yale University. Jonathan Turley is the J.B. and Maurice C. Shapiro Chair of Public Interest Law at George Washington University Law School, where he teaches torts, criminal procedure, and constitutional law. After a stint at Tulane Law School, Professor Turley joined the GW Law faculty in 1990, and in 1998 became the youngest chaired professor in the school's history. He has written over 36 academic articles for a variety of leading law journals, and his articles on legal and policy issues appear frequently in national publications. A Chicago native, Professor Turley earned degrees from the University of Chicago and Northwestern University School of Law. We welcome all our distinguished witnesses. We thank them for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show the witnesses answered in the affirmative. Thank you, and please be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 10 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 10 minutes have expired. Professor Feldman, you may begin. I don't think you're on the mic.
Mr. Chairman, before we begin,
Mr. Chairman and members of the committee.
Mr. Chairman, I have a motion.
The gentleman is not in order to offer a motion at this time.
Mr. Chairman, I seek recognition for a privilege motion.
Mr. Chairman and members of the committee, thank you very much for the opportunity to appear. My name is Noah Feldman. I serve as the
witness will proceed.
I serve as the Felix Frankfurter Professor of Law at the Harvard Law School.
I seek recognition
My
for
job
privilege
is
motion.
to study.
The gentleman will suspend. The time is the witnesses.
The privilege motion needs to be recognized. You can call it not a privilege, but you need to be
between the
recognized.
witnesses, it may be recognized. Not once I recognize the witness.
So
The witness will proceed. We'll entertain the motion after the first witness.
My job is to study and to teach the Constitution from its origins until the present. I'm here today to describe three things: why the framers of our Constitution included a provision for the impeachment of the president, what that provision providing for impeachment for high crimes and misdemeanors means, and last, how it applies to the question before you and before the American people, whether President Trump has committed impeachable offenses under the Constitution. Let me begin by stating my conclusions. The framers provided for the impeachment of the president because they feared that the president might abuse the power of his office for personal benefit, to corrupt the electoral process and ensure his re-election, or to subvert the national security of the United States. High crimes and misdemeanors are abuses of power and of public trust connected to the office of the presidency. On the basis of the testimony and the evidence before the House, President Trump has committed impeachable high crimes and misdemeanors by corruptly abusing the office of the presidency. Specifically, President Trump has abused his office by corruptly soliciting President Volodymyr Zelensky of Ukraine to announce investigations of his political rivals in order to gain personal advantage, including in the 2020 presidential election. Let me begin now with the question of why the framers provided for impeachment in the first place. The framers borrowed the concept of impeachment from England, but with one enormous difference. The House of Commons and the House of Lords could use impeachment in order to limit the ministers of the king, but they could not impeach the king, and in that sense, the king was above the law. In stark contrast, the framers, from the very outset of the Constitutional Convention in 1787, made it crystal clear that the president would be subject to impeachment in order to demonstrate that the president was subordinate to the law. If you will, I would like you to think now about a specific date in the Constitutional Convention, July 20th, 1787. It was the middle of a long, hot summer, and on that day, two members of the Constitutional Convention actually moved to take out the impeachment provision from the draft Constitution. And they had a reason for that, and their reason was, they said, well, the president will have to stand for re-election. And if the president has to stand for re-election, that is enough. We don't need a separate provision for impeachment. When that proposal was made, significant disagreement ensued. The governor of North Carolina, a man called William Davey, immediately said, if the president cannot be impeached, quote, he will spare no efforts or means whatever to get himself reelected. Following Davey, George Mason of Virginia, a fierce Republican critic of executive power, said, no point is more important than that impeachment be included in the Constitution. Shall any man be above justice? He asked, thus expressing the core concern that the president must be subordinate to the law and not above the law. James Madison, the principal draftsman of the U.S. Constitution, then spoke up. He said it was, quote, indispensable that some provision be made for impeachment. Why? Because, he explained, standing for re-election was, quote, not a sufficient security, close quote, against presidential misconduct or corruption. A president, he said, might betray his trust to foreign powers. A president who, in a corrupt fashion, abused the office of the presidency, said James Madison, quote, might be fatal to the republic, close quote. And then a remarkable thing happened in the convention. Gouverneur Morris of Pennsylvania, one of the two people who had introduced the motion to eliminate impeachment from the Constitution, got up and actually said the words, I was wrong. He told the other framers present that he had changed his mind on the basis of the debate on July 20th, and that it was now his opinion that in order to avoid corruption of the electoral process, a president would have to be subject to impeachment regardless of the availability of a further election. The upshot of this debate is that the framers kept impeachment in the Constitution specifically in order to protect against the abuse of office with the capacity to corrupt the electoral process or lead to personal gain. Now, turning to the language of the Constitution, the framers used the words high crimes and misdemeanors to describe those forms of action that they considered impeachable. These were not vague or abstract terms to the framers. High crimes and misdemeanors were the words high crimes and misdemeanors represented very specific language that was well understood by the entire generation of the framers. Indeed, they were borrowed from an impeachment trial in England that was taking place as the framers were speaking, which was referred to, in fact, by George Mason. The words high crimes and misdemeanors refer to abuse of the office of the presidency for personal advantage, or to corrupt the electoral process, or to subvert the national security of the United States. There's no mystery about the words high crimes and misdemeanors. The word high modifies both crimes and misdemeanors, so they're both high. And high means connected to the office of the presidency, connected to office. The classic form that was familiar to the framers was the abuse of office for personal gain or advantage. And when the framers specifically named bribery as a high crime and misdemeanor, they were naming one particular version of this abuse of office, the abuse of office for personal or individual gain. The other forms of abuse of office to affect elections, and abuse of office to compromise national security, were further forms that were familiar to the framers. Now, how does this language of high crimes and misdemeanors apply to President Trump's alleged conduct? Let me be clear. The Constitution gives the House of Representatives, that is, the members of this committee and the other members of the House, quote, sole power of impeachment. It's not my responsibility or my job to determine the credibility of the witnesses who appeared before the House thus far. That is your constitutional responsibility. My comments will, therefore, follow my role, which is to describe and apply the meaning of impeachable offenses to the facts described by the testimony and evidence before the House. President Trump's conduct, as described in the testimony and evidence, clearly constitutes impeachable high crimes and misdemeanors under the Constitution. In particular, the memorandum and other testimony relating to the July 25th, 2019 phone call between the two presidents, President Trump and President Zelensky, more than sufficiently indicates that President Trump abused his office by soliciting the president of Ukraine to investigate his political rivals in order to gain personal political advantage, including in relation to the 2020 election. Again, the words abuse of office are not mystical or magical. They are very clear. The abuse of office occurs when the president uses a feature of his power, the awesome power of his office, not to serve the interests of the American public, but to serve his personal, individual, partisan, electoral interests. That is what the evidence before the House indicates. Finally, let me be clear that on its own, soliciting the leader of a foreign government in order to announce investigations of political rivals and perform those investigations would constitute a high crime and misdemeanor. But the House also has evidence before it that the president committed 2 further acts that also qualify as high crimes and misdemeanors. In particular, the House heard evidence that the president placed a hold on critical U.S. aid to Ukraine and conditioned its release on announcement of the investigations of the Bidens and of the discredited CrowdStrike conspiracy theory. Furthermore, the House also heard evidence that the president conditioned a White House visit desperately sought by the Ukrainian president on announcement of the investigations. Both of these acts constitute impeachable high crimes and misdemeanors under the Constitution. They each encapsulate the framers' worry that the President of the United States would take any means whatever to ensure his reelection. And that is the reason that the framers provided for impeachment in a case like this one.
Mr. Chairman, I seek
Gentleman's
recognition.
time has expired.
Mr. Chairman, I seek recognition.
The gentleman is recognized.
I offer a motion to postpone to a date certain.
I move to table the motion.
Motion to table is heard and is not debatable. All in favor of the motion to
Mr.
table?
Chairman,
All in
Mr.
favor of the
Chairman, May
motion?
we have the motion read, please?
The motion was stated as to adjourn to its date.
May we have the motion read,
The
please?
motion will be read as to what date?
Motion to be read to a date certain, Wednesday, December 11, 2019, so we can actually get a response to the 6 letters.
The gentleman has stated his motion. The motion to table is made.
Correct.
Motion to table is made and not debatable. All in favor? The motion to table will say aye. Aye. Opposed?
No.
The motion to table is agreed to.
Roll call.
Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee?
Aye.
Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Richmond?
Yes.
Mr. Richmond votes yes. Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Yes.
Mr. Swalwell votes yes. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Steen?
Aye.
Ms. Steen votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler?
No.
Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong? No. Mr. Armstrong votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no.
Has everyone voted who wishes to vote? The clerk will report.
Mr. Chairman, there are 24 ayes and 17 noes.
The motion to table is adopted, and I now recognize Professor Carlin for her testimony.
Mr. Chairman and members of the committee, thank you so much for the opportunity to testify. Twice I have had the privilege of representing this committee and its leadership in voting rights cases before the Supreme Court. Once when it was under the leadership of Chairman Sensenbrenner, and it's good to see you again, sir, and with Mr. Shabbat as one of my other clients, and once under the leadership of Chairman Conyers. It was a great honor for me to represent this committee because of this committee's key role over the past 50 years in ensuring that American citizens have the right to vote in free and fair elections. Today, you're being asked to consider whether protecting those elections requires impeaching a president. That is an awesome responsibility. But everything I know about our Constitution and its values, and my review of the evidentiary record, and here, Mr. Collins, I would like to say to you, sir, that I read transcripts of every one of the witnesses who appeared in the live hearing because I would not speak about these things without reviewing the facts. So I'm insulted by the suggestion that as a law professor I don't care about those facts. But everything I read on those occasions tells me that when President Trump invited, indeed demanded foreign involvement in our upcoming election, he struck at the very heart of what makes this a republic to which we pledge allegiance. That demand, as Professor Feldman just explained, constituted an abuse of power. Indeed, as I want to explain in my testimony, drawing a foreign government into our elections is an especially serious abuse of power because it undermines democracy itself. Our Constitution begins with the words, "We the people," for a reason. Our government, in James Madison's words, derives all its powers directly or indirectly from the great body of the people. And the way it derives these powers is through elections. Elections matter, both to the legitimacy of our government and to all of our individual freedoms, because as the Supreme Court declared more than a century ago, voting is preservative of all rights. So it is hardly surprising that the Constitution is marbled with provisions governing elections and guaranteeing governmental accountability. Indeed, a majority of the amendments to our Constitution since the Civil War have dealt with voting or with terms of office. And among the most important provisions of our original Constitution is the guarantee of periodic elections for the presidency, one every 4 years. America has kept that promise for more than 2 centuries, and it has done so even during wartime. For example, we invented the idea of absentee voting so that Union troops who supported President Lincoln could stay in the field during the election of 1864. And since then, countless other Americans have fought and died to protect our right to vote. But the framers of our Constitution realized that elections alone could not guarantee that the United States would remain a republic. One of the key reasons for including the impeachment power was a risk that unscrupulous officials might try to rig the election process. Now, you've already heard 2 people give William Davey his props. Hamilton got a whole musical, and William Davey is just going to get this committee hearing. But he warned that unless the Constitution contained an impeachment provision, a president might spare no efforts or means whatsoever to get himself reelected. And George Mason insisted that a president who procured his appointment in the first instance through improper and corrupt acts should not escape punishment by repeating his guilt. And Mason was the person responsible for adding high crimes and misdemeanors to the list of impeachable offenses. So we know from that the list was designed to reach a president who acts to subvert an election, whether that election is the one that brought him into office or it's an upcoming election where he seeks an additional term. Moreover, the founding generation, like every generation of Americans since, was especially concerned to protect our government and our democratic process from outside interference. For example, John Adams, during the ratification, expressed concern with the very idea of having an elected president, writing to Thomas Jefferson that "You are apprehensive of foreign interference, intrigue, influence. So am I. But as often as elections happen, the danger of foreign influence recurs." And in his farewell address, President Washington warned that history and experience prove that foreign influence is one of the most baneful foes of Republican government. And he explained that this was in part because foreign governments would try and foment disagreement among the American people and influence what we thought. The very idea that a president might seek the aid of a foreign government in his reelection campaign would have horrified them. But based on the evidentiary record, that is what President Trump has done. The list of impeachable offenses that the framers included in the Constitution shows that the essence of an impeachable offense is a president's decision to sacrifice the national interest for his own private ends. Treason, the first thing listed, lay in an individual's giving aid to a foreign enemy. That is, putting a foreign enemy's adversary's interests above the interests of the United States. Bribery occurred when an official solicited, received, or offered a personal favor or benefit to influence official action, risking that he would put his private welfare above the national interest. And high crimes and misdemeanors captured the other ways in which a high official might, as Justice Joseph Story explained, disregard public interests in the discharge of the duties of political office. Based on the evidentiary record before you, what has happened in the case today is something that I do not think we have ever seen before. A president who has doubled down on violating his oath to faithfully execute the laws and to protect and defend the Constitution. The evidence reveals a president who used the powers of his office to demand that a foreign government participate in undermining a competing candidate for the presidency. As President John Kennedy declared, the right to vote in a free American election is the most powerful and precious right in the world. But our elections become less free when they are distorted by foreign interference. What happened in 2016 was bad enough. There is widespread agreement that Russian operatives intervened to manipulate our political process. But that distortion is magnified if a sitting president abuses the powers of his office actually to invite foreign intervention. To see why, imagine living in a part of Louisiana or Texas that's prone to devastating hurricanes and flooding. What would you think if you lived there and your governor asked for a meeting with the president to discuss getting disaster aid that Congress has provided for? What would you think if that president said, I would like you to do us a favor. I'll meet with you, and I'll send the disaster relief once you brand my opponent a criminal? Wouldn't you know in your gut that such a president had abused his office, that he'd betrayed the national interest, and that he was trying to corrupt the electoral process? I believe that the evidentiary record shows wrongful acts on that scale here. It shows a president who delayed meeting a foreign leader and providing assistance that Congress and his own advisors agreed serves our national interest in promoting democracy and in limiting Russian aggression. Saying, Russia, if you're listening, you know, a president who cared about the Constitution would say, Russia, if you're listening, butt out of our elections. And it shows a president who did this to strong-arm a foreign leader into smearing one of the president's opponents in our ongoing election season. That's not politics as usual, at least not in the United States or not in any mature democracy. It is instead a cardinal reason why the Constitution contains an impeachment power. Put simply, a president should resist foreign interference in our elections, not demand it and not welcome it. If we are to keep faith with our Constitution and with our republic, President Trump must be held to account. Thank you.
Thank you, Professor Gerhart.
Thank you, Mr. Chairman, ranking member, other distinguished members of the committee. It's an honor and a privilege to join the other distinguished witnesses to discuss a matter of grave concern to our country and to our Constitution. Because this House, the People's House, has the sole power of impeachment, there is no better forum to discuss the constitutional standard for impeachment and whether that standard has been met in the case of the current President of the United States. As I explain in the remainder and balance of my opening statement, the record compiled thus far shows the President has committed several impeachable offenses, including bribery, abuse of power, and soliciting a personal favor from a foreign leader to benefit himself personally, obstructing justice, and obstructing Congress. Our hearing today should serve as a reminder of one of the fundamental principles that drove the founders of our Constitution to break from England and to draft their own Constitution, the principle that in this country, no one is king. We have followed that principle since before the founding of the Constitution, and it is recognized around the world as a fixed, inspiring American ideal. In his third message to Congress in 1903, President Theodore Roosevelt delivered one of the finest articulations of this principle. He said, "No one is above the law, and no man is below, nor do we ask any man's permission when we require him to obey it. Obedience to the law is demanded as a right, not asked for as a favor." Three features of our Constitution protect the fundamental principle that no one, not even the President, is above the law. First, in the British system, the public had no choice over the monarch who ruled them. In our Constitution, the framers allowed elections to serve as a crucial means for ensuring presidential accountability. Second, in the British system, the king could do no wrong, and no other parts of the government could check his misconduct. In our Constitution, the framers developed the concept of separation of powers, which consists of checks and balances designed to prevent any branch, including the presidency, from becoming tyrannical. Third, in the British system, everyone but the king was impeachable. Our framers' generation pledged their lives and fortunes to rebel against a monarch whom they saw as corrupt, tyrannical, and entitled to do no wrong. In our Declaration of Independence, the framers set forth a series of impeachable offenses that the king had committed against the American colonists. When the framers later convened in Philadelphia to draft our Constitution, they were united around a simple, indisputable principle that was a major safeguard for the public: we the people, against tyranny of any kind. A people who had overthrown a king were not going to turn around just after securing their independence from corrupt monarchical tyranny and create an office that, like the king, was above the law and could do no wrong. The framers created a chief executive to bring energy to the administration of federal laws, but to be accountable to Congress for treason, bribery, or other high crimes and misdemeanors. The framers' concern about the need to protect against a corrupt president was evident throughout the convention. And here I must thank my prior two friends who have spoken and referred to a North Carolinian, William Davie. I will refer to another North Carolinian in the Constitutional Convention, James Iredell, whom President Washington later appointed to the Supreme Court, assured his fellow delegates, the president, quote, is of a very different nature from a monarch. He is to be personally responsible for any abuse of the great trust placed in him, unquote. This brings us, of course, to the crucial question we're here to talk about today, the standard for impeachment. The Constitution defines treason, and the term bribery basically means using office for personal gain, or I should say misusing office for personal gain. And as Professor Feldman pointed out, these terms derive from the British, who understood the class of cases that would be impeachable to refer to political crimes, which included great offenses against the United States, attempts to subvert the Constitution, when the president deviates from his duty or dares to abuse the power invested in him by the people, breaches of the public trust, and serious injuries to the republic. In his influential essay in the Federalist Papers, Alexander Hamilton declared that impeachable offenses are those offenses which proceed from the misconduct of public men, or in other words, the abuse or violation of some public trust, and relate chiefly to injuries done immediately to the society itself. Several themes emerge from the framers' discussion of the scope of impeachable offenses and impeachment practice. We know that not all impeachable offenses are criminal, and we know that not all felonies are impeachable offenses. We know further that what matters in determining whether particular misconduct constitutes a high crime and misdemeanor is ultimately the context and the gravity of the misconduct in question. After reviewing the evidence that's been made public, I cannot help but conclude that this president has attacked each of the Constitution's safeguards against establishing a monarchy in this country. Both the context and gravity of the president's misconduct are clear. The favor he requested from Ukraine's president was to receive, in exchange for his use of presidential power, Ukraine's announcement of a criminal investigation of a political rival. The investigation was not the important action for the president. The announcement was, because it could then be used in this country to manipulate the public into casting aside the president's political rival because of concerns about his corruption. The gravity of the president's misconduct is apparent when we compare it to the misconduct of the one president who resigned from office to avoid impeachment, conviction, and removal. The House Judiciary Committee in 1974 approved 3 articles of impeachment against Richard Nixon, who resigned a few days later. The first article charged him with obstruction of justice. If you read the Mueller report, it identifies a number of facts, I won't lay them out here right now, that suggest the president himself has obstructed justice. If we look at the second article of impeachment approved against Richard Nixon, it charged him with abuse of power for ordering the heads of the FBI, IRS, and CIA to harass his political enemies. In the present circumstance, the president has engaged in a pattern of abusing the trust placed in him by the American people by soliciting foreign countries, including China, Russia, and Ukraine, to investigate his political opponents and interfere on his behalf in elections in which he is a candidate. The third article approved against President Nixon charged that he had failed to comply with 4 legislative subpoenas. In the present circumstance, the president has refused to comply with and directed at least 10 others in his administration not to comply with lawful congressional subpoenas, including Secretary of State Mike Pompeo, Energy Secretary Rick Perry, and Acting Chief of Staff and Head of the Office of Management and Budget, Mick Mulvaney. As Senator Lindsey Graham, now chair of the Senate Judiciary Committee, said when he was a member of the House on the verge of impeaching President Clinton, the day Richard Nixon failed to answer that subpoena is the day he was subject to impeachment because he took the power from Congress, over the impeachment process away from Congress, and he became the judge and jury. That is a perfectly good articulation of why obstruction of Congress is impeachable. The president's defiance of Congress is all the more troubling due to the rationale he claims for his obstruction. His arguments and those of his subordinates, including his White House counsel, in his October 8th letter to the Speaker and 3 committee chairs, boils down to the assertion that he is above the law. I won't reread that letter here, but I do want to disagree with the characterization in the letter of these proceedings, since the Constitution expressly says, and the Supreme Court has unanimously affirmed, that the House has the sole power of impeachment, and like the Senate, the House has the power to determine the rules for its proceedings. The President and his subordinates have argued further that the President is entitled to absolute immunity from criminal procedure, even an investigation for any criminal wrongdoing, including shooting someone on Fifth Avenue. The President has claimed further he's entitled to absolute executive privilege, not to share any information he doesn't want to share with another branch. He's also claimed the entitlement to be able to order the executive branch, as he's done, not to cooperate with this body when it conducts an investigation of the president. If left unchecked, the president will likely continue his pattern of soliciting foreign interference on behalf of the next election, and of course, his obstruction of Congress. The fact that we can easily transpose the articles of impeachment against President Nixon onto the actions of this president speaks volumes, and that does not even include the most serious national security concerns and election interference concerns at the heart of this president's misconduct. No misconduct is more antithetical to our democracy, and nothing injures the American people more than a president who uses his power to weaken their authority under the Constitution, as well as the authority of the Constitution itself. May I read one more sentence, or I'm sorry.
The witness may have another sentence or two.
Thank you. If Congress fails to impeach here, then the impeachment process has lost all meaning. And along with that, our Constitution's carefully crafted safeguards against the establishment of a king on American soil, and therefore, I stand with the Constitution, and I stand with the framers who were committed to ensure that no one is above the law.
Thank you, Professor. Professor Turley.
Thank you, Chairman Nadler, Ranking Member Collins, members of the Judiciary Committee. It's an honor to appear before you today to discuss one of the most consequential functions you were given by the framers, and that is the impeachment of a President of the United States. 21 years ago, I sat before you, Chairman Nadler, and this committee to testify at the impeachment of President William Jefferson Clinton. I never thought that I would have to appear a second time to address the same question with regard to another sitting president. Yet here we are. The elements are strikingly similar. The intense rancor and rage of the public debate is the same. It's the atmosphere that the framers anticipated. The stifling intolerance of opposing views is the same. I'd like to start, therefore, perhaps incongruously, by stating an irrelevant fact. I'm not a supporter of President Trump. I voted against him. My personal views of President Trump are as irrelevant to my impeachment testimony as they should be to your impeachment vote. President Trump will not be our last president, and what we leave in the wake of this scandal will shape our democracy for generations to come. I'm concerned about lowering impeachment standards to fit a paucity of evidence and an abundance of anger. I believe this impeachment not only fails to satisfy the standard of past impeachments, but would create a dangerous precedent for future impeachments. My testimony lays out the history of impeachment from early English cases to colonial cases to the present day. The early impeachments were raw political exercises using fluid definitions of criminal and non-criminal acts. When the framers met in Philadelphia, they were quite familiar with impeachment and its abuses, including the Hastings case, which was discussed in the convention, a case that was still pending for trial in England. Unlike the English impeachments, the American model was more limited, not only in its application to judicial and executive officials, but its grounds. The framers rejected a proposal to add maladministration because Madison objected that so vague a term would be equivalent to a tenure during the pleasure of the Senate. In the end, various standards that had been used in the past were rejected. Corruption, obtaining office by improper means, betraying the trust of a foreign power, negligence, perfidy, peculation, and oppression. Perfidy or lying and peculation, self-dealing, are particularly relevant to our current controversy. My testimony explores the impeachment cases of Nixon, Johnson, and Clinton. The closest of these three cases is to the 1868 impeachment of Andrew Johnson. It is not a model or an association that this committee should relish. In that case, a group of opponents of the presidents, called the Radical Republicans, created a trapdoor crime in order to impeach the president. They even defined it as a high misdemeanor. There was another shared aspect besides the atmosphere of that impeachment and also the unconventional style of the two presidents. And that shared element is speed. This impeachment would rival the Johnson impeachment as the shortest in history, depending on how one counts the relevant days. Now, there are three distinctions when you look at these, or three commonalities when you look at these past cases. All involved established crimes. This would be the first impeachment in history where there would be considerable debate, and in my view, not compelling evidence of the commission of a crime. Second is the abbreviated period of this investigation, which is problematic and puzzling. This is a facially incomplete and inadequate record in order to impeach a president. Allow me to be candid in my closing remarks because we have limited time. We are living in the very period described by Alexander Hamilton, a period of agitated passions. I get it. You're mad. The president's mad. My Republican friends are mad. My Democratic friends are mad. My wife is mad. My kids are mad. Even my dog seems mad. And Luna's a golden doodle, and they don't get mad. So we're all mad. Where has that taken us? Will a slipshod impeachment make us less mad? Will it only invite an invitation for the madness to follow every future administration? That is why this is wrong. It's not wrong because President Trump is right. His call was anything but perfect. It's not wrong because the House has no legitimate reason to investigate the Ukrainian controversy. It's not wrong because we're in an election year. There is no good time for an impeachment. No, it's wrong because this is not how you impeach an American president. This case is not a case of the unknowable. It's a case of the peripheral. We have a record of conflicts, defenses that have not been fully considered, unsubpoenaed witness with material evidence. To impeach a president on this record would expose every future president to the same type of inchoate impeachment. Principle often takes us to a place we would prefer not to be. That was the place 7 Republicans found themselves in the Johnson trial, when they saved a president from acquittal that they despised. For generations, they've been celebrated as profiles of courage. Senator Edmund Ross said it was like looking down into his open grave. And then he jumped because he didn't have any alternative. It's easy to celebrate those people from the distance of time and circumstance. In an age of rage, it's appealing to listen to those saying, forget the definitions of crimes, just do it. Like this is some impulse buy Nike sneaker. You can certainly do that. You can declare the definitions of crimes alleged are immaterial and just an exercise of politics, not the law. However, those legal definitions and standards, which I've addressed in my testimony, are the very thing that divide rage from reason. This all brings up to me, and I will conclude with this, of a scene from A Man for All Seasons with Sir Thomas More, when his son-in-law, William Roper, suggested that More was putting the law ahead of morality. He said More would give the devil the benefit of the law. When More asks Roper, would he instead cut a great road through the law to get after the devil? Roper proudly declares, yes. I'd cut down every law of England to do that. More responds, and when the last law is cut down and the devil turned around on you, where would you hide, Roper? All the laws being flat. He said, this country is planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? And he finished by saying, yes, I'd give the devil the benefit of the law for my own sake. So I will conclude with this. Both sides of this controversy have demonized the other to justify any measure in their defense, much like Roper. Perhaps that's the saddest part of all of this. We have forgotten the common article of faith that binds each of us to each other in our Constitution. However, before we cut down the trees so carefully planted by the framers, I hope you will consider what you will do when the wind blows again, perhaps for a Democratic president. Where will you stand then when all the laws being flat? Thank you again for the honor of testifying today, and I'd be happy to answer any questions.
I thank the witnesses.
Mr. Chairman, I seek recognition.
Who seeks recognition?
Me, Mr. Chairman.
For what purpose does the gentleman seek recognition?
Mr. Chairman, I have a motion pursuant to Rule 11, specifically 2K6. I move to subpoena the individual commonly referred to as the whistleblower. I asked to do this in executive
The gentleman
session.
has stated his motion. Do I hear a motion to table?
I move to table the motion.
Motion is to table. All in favor say aye. Aye. Opposed, no?
No. Mr. Chairman, roll call
The
vote.
motion to table is approved. The roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye, Ms. Lofgren.
Aye.
Ms. Lofgren votes aye, Ms. Jackson-Lee.
Aye.
Ms. Jackson-Lee votes aye, Mr. Cohen.
Aye.
Mr. Cohen votes aye, Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye, Mr. Deutsch.
Aye.
Mr. Deutsch votes aye, Ms. Bass.
Aye.
Ms. Bass votes aye, Mr. Richmond. Mr. Richmond votes aye, Mr. Jeffries. Mr. Jeffries votes aye, Mr. Cicilline. Mr. Cicilline votes aye, Mr. Swalwell.
Aye.
Mr. Swalwell votes aye, Mr. Liu. Mr. Liu votes aye, Mr. Raskin.
Aye.
Mr. Raskin votes aye, Ms. Jayapal. Ms. Jayapal votes aye, Ms. Demings. Ms. Demings votes aye, Mr. Correa. Mr. Correa votes aye, Ms. Scanlon.
Aye.
Ms. Scanlon votes aye, Ms. Garcia.
Aye.
Ms. Garcia votes aye, Mr. Neguse. Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Sensenbrenner? Mr. Shabbat? No. Mr. Shabbat votes no. Mr. Gomert? No. Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? No. Mr. Johnson of Louisiana votes no. Mr. Biggs? Did he say no? Mr. Biggs? No. Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler?
No.
Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong?
No.
Mr. Armstrong votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no.
Has everyone voted who wishes to vote?
Mr. Chairman, how am I recorded?
Mr. Collins, you are not recorded.
No.
Mr. Collins votes no.
Is there anyone else who wishes to vote?
Mr. Chairman, how am I recorded?
Mr. Sensenbrenner, you are not recorded.
No.
Mr. Sensenbrenner votes no.
Anyone else? The clerk will report.
Mr. Chairman, there are 24 ayes and 17 noes.
The motion to table is adopted. We will now proceed to the first round of questions. Pursuant to House Resolution 660 and its accompanying Judiciary Committee procedures, there will be 45 minutes of questions conducted by the Chairman or Majority Counsel, followed by 45 minutes for the Ranking Member or Minority Counsel. Only the Chair and Ranking Member and their respective counsels may question witnesses during this period. Following that, unless I specify additional equal time for extended questioning, we will proceed under the 5-minute rule, and every member will have the chance to ask questions. I now recognize myself for the first round of questions. Professors, thank you for being here today. The committee has been charged with the grave responsibility of considering whether to recommend articles of impeachment against the President. I speak for my colleagues when I say that we do not take this lightly, and we are committed to ensuring that today's hearing, as well as the larger responsibility before us, are grounded in the Constitution. The Intelligence Committee's report concluded that the President pressured a foreign leader to interfere in our elections by initiating and denouncing investigations into President Trump's political adversaries. He then sought to prevent Congress from investigating his conduct by ordering his administration and everyone in it to defy House subpoenas. Professor Carlin, as you said, the right to vote is the most precious legal right we have in this country. Does the President's conduct endanger that right?
Yes, Mr. Chairman, it does.
Thank you. And how does it do so?
The way that it does it is exactly what President Washington warned about. By inviting a foreign government to influence our elections, it takes the right away from the American people, and it turns that into a right that foreign governments decide to interfere for their own benefit. Foreign governments don't interfere in our elections to benefit us. They intervene to benefit themselves.
Thank you. Professor Gerhart, you have written extensively about our system of checks and balances. What happens to that system when the President undertakes a blockade of Congress's impeachment inquiry, when he orders all witnesses not to testify? And what is our recourse?
When a president does that, separation of powers means nothing. The subpoenas that have been issued, of course, are lawful orders. In our law schools, we would teach our students, this is an easy, straightforward situation. You comply with the law. Lawyers all the time have to comply with subpoenas. But in this situation, the full-scale obstruction of those subpoenas, I think torpedoes separation of powers, and therefore your only recourse is to in a sense, protect your institutional prerogatives, and that would include impeachment.
And the same is true of defying congressional subpoenas on a wholesale basis with respect to oversight, not just to impeachment?
Absolutely. Yes, sir.
Thank you. Professor Feldman, as I understand it, the framers intended impeachment to be used infrequently, not as punishment, but to save our democracy from threats so significant that we cannot wait for the next election. In your testimony, you suggest that we face that kind of threat. Can you explain why you think impeachment is the appropriate recourse here, why we cannot wait for the next election? Those are two questions if you want them to be.
The framers reserved impeachment for situations where the president abused his office, that is, used it for his personal advantage, and in particular, they were specifically worried about a situation where the president used his office to facilitate corruptly his own reelection. That's in fact why they thought they needed impeachment and why waiting for the next election wasn't good enough. On the facts that we have before the House right now, the president solicited assistance from a foreign government in order to assist his own reelection. That is, he used the power of his office that no one else could possibly have used in order to gain personal advantage for himself, distorting the election. And that's precisely what the framers anticipated.
Thank you very much. And I now yield the remainder of my time to Mr. Eisen for council questions. Mr.
Professors, good morning. Thank you for being here. I want to ask you some questions about the following high crimes and misdemeanors that were mentioned in the opening statements: abuse of power and bribery, obstruction of Congress, and obstruction of justice. Professor Feldman, what is abuse of power?
Abuse of power is when the president uses his office, takes an action that is part of the presidency, not to serve the public interest, but to serve his private benefit. And in particular, it's an abuse of power if he does it to facilitate his reelection or to gain an advantage that is not available to anyone who is not the president.
Sir, why is that impeachable conduct?
If the president uses his office for personal gain, the only recourse available under the Constitution is for him to be impeached, because the president cannot be, as a practical matter, charged criminally while he is in office, because the Department of Justice works for the president. So the only mechanism available for a president who tries to distort the electoral process for personal gain is to impeach him. That is why we have impeachment.
Professor Carlin, do scholars of impeachment generally agree that abuse of power is an impeachable offense?
Yes, they do.
Professor Gerhart, do you agree that abuse of power is impeachable?
Yes, sir.
I'd like to focus the panel on the evidence they considered and the findings in the Intelligence Committee report that the president solicited the interference of a foreign government, Ukraine, in the 2020 U.S. presidential election. Professor Feldman, did President Trump commit the impeachable high crime and misdemeanor of abuse of power based on that evidence and those findings?
Based on that evidence and those findings, the president did commit an impeachable abuse of office.
Professor Carlin, same question.
Same answer.
And Professor Gerhart, did President Trump commit the impeachable high crime and misdemeanor of abuse of power?
We three are unanimous, yes.
Professor Feldman, I'd like to quickly look at the evidence and the report. On July 25th, President Trump told the president of Ukraine, and I quote, "I would like you to do us a favor, though." And he asked about looking into the Bidens. Was the memorandum of that call relevant to your opinion that the president committed abuse of power?
The memorandum of that call between the two presidents is absolutely crucial to the determination, to my determination, that the president abused his office.
And did you consider the findings of fact that the Intelligence Committee made, including that, and again, I quote, "The president withheld official acts of value to Ukraine and conditioned their fulfillment on actions by Ukraine that would benefit his personal political interests"?
Yes, in making the determination that the president committed an impeachable offense, I relied on the evidence that was before the House and the testimony, and then when this report was issued, I continued to rely on that.
Sir, did you review the following testimony from our ambassador to Ukraine, Ambassador William Taylor?
To withhold that assistance for no good reason other than help with the political campaign made no sense. It was counterproductive to all of what we had been trying to do. It was illogical. It could not be explained. It was crazy.
Yes, that evidence underscored the way that the president's actions undercut national security.
Professor Feldman, will you please explain why you concluded that the president committed the high crime of abuse of power and why it matters?
The abuse of power occurs when the president uses his office for personal advantage or gain. That matters fundamentally to the American people because if we cannot impeach a president who abuses his office for personal advantage, we no longer live in a democracy. We live in a monarchy or we live under a dictatorship. That's why the framers created the possibility of impeachment.
Now, Professor Carlin, this high crime and misdemeanor of abuse of power, was it some kind of loose or undefined concept to the founders of our country and the framers of our Constitution?
No, I don't think it was it was a loose concept at all. It had a long lineage in the common law in England of parliamentary impeachments of lower-level officers. Obviously, they had not talked about impeaching, as you've heard earlier, the king or the like.
And can you share a little bit about that lineage, please?
Yes. So the Parliament in England impeached officers of the Crown when those people abused their power. And if I could give you one example that might be a little helpful here, right after the restoration of the kingship in England, there was an impeachment, and when they impeached somebody, they had to say what were they impeaching him for. So sometimes it would be, we're impeaching him for treason or the like, and sometimes they would use the phrase high crime or misdemeanor. And there was an impeachment of Viscount Mordaunt, which is a great name to have, but Viscount Mordaunt, and he was impeached because he was the sheriff of Windsor, and as the parliamentary election was coming up, he arrested William Taylor, and I just want to read to you from the article of impeachment in front of the House of Commons, because it's so telling. Here's what Article 1 of the impeachment said. It said, understanding that one William Taylor did intend to stand for the election of one of the burgesses of the borough of Windsor to serve in this present Parliament. In other words, he was running as a member of Parliament. This is what Viscount Mordaunt did. To disparage and prevent the free election of the said William Taylor and strike a terror into those of the said borough which should give their voices for him and deprive them of the freedom of their voices at the election, Viscount Mordaunt did command and cause the said William Taylor to be forcibly, illegally, and arbitrarily seized upon by soldiers, and then he detained him. In other words, he went after a political opponent, and that was a high crime or misdemeanor to use your office to go after a political opponent.
Now, Professor Gerhart, does a high crime and misdemeanor require an actual statutory crime?
No, it plainly does not. Everything we know about the history of impeachment reinforces the conclusion that impeachable offenses do not have to be crimes, and again, not all crimes are impeachable offenses. We look at, again, at the context and gravity of the misconduct.
And Professor Turley, you recently wrote in the Wall Street Journal, and I quote, "There is much that is worthy of investigation in the Ukraine scandal, and it is true that impeachment doesn't require a crime."
That's true, but I also added an important caveat. First of all,
Sir, it was a yes or a no question. Did you write in the Wall Street Journal, "There is much that is worthy of investigation in the Ukraine scandal, and it is true that impeachment does not require a crime"? Is that an accurate quote, sir?
You've read it well.
So, Professors Feldman, Carlin, and Gerhart, you have identified that on the evidence here, there is an impeachable act, a high crime and misdemeanor of abuse of power, correct?
Correct.
Yes.
Yes.
And Professor Feldman, what does the Constitution say is the responsibility of the House of Representatives in dealing with presidential high crimes and misdemeanors like abuse of power?
The Constitution gives the House of Representatives the sole power of impeachment. That means the House has the right and the responsibility to investigate presidential misconduct and, where appropriate, to create and pass articles of impeachment.
And Professor Carlin, what does that responsibility mean for this committee with respect to President Trump's abuse of power?
Well, because this is an abuse that cuts to the heart of democracy, you need to ask yourselves, if you don't impeach a president who has done what this president has done, or at least you don't investigate and then impeach if you conclude that the House Select Committee on Intelligence findings are correct, then what you're saying is it's fine to go ahead and do this again. And I think that as in the report that came out last night, the report talks about the clear and present danger to the election system. And it's your responsibility to make sure that all Americans get to vote in a free and fair election next November.
Professor Carlin, I'd like to direct you to the words in the Constitution, other high crimes and misdemeanors. We're still going to talk about abuse of power. Can I ask, did the Constitution spell out every other high crime and misdemeanor?
No, it did not.
Please
in part because they recognized that the inventiveness of man and the likelihood that this Constitution would endure for generations meant they couldn't list all of the crimes that might be committed. They couldn't imagine an abuse of power, for example, that involved burglarizing and stealing computer files from an adversary because they couldn't have imagined computers. They couldn't necessarily have imagined wiretapping because we had no wires in 1789. So what they did is they put in a phrase that the English had used and that had adapted over a period of centuries to take into account that the idea of high crimes and misdemeanors is to get at things that people in office use to strike at the very heart of our democracy.
And Professor, in your written testimony, you mentioned two additional aspects of high crimes and misdemeanors besides abuse of power. You talked about betrayal of the national interest, betrayal of the national interest, and corruption of the electoral process. Can you say a little bit more about what the framers' concerns were about corruption of elections and betrayal of the national interest involving foreign powers and how they come into play here?
Sure. So let me start with the framers and what they were concerned with and then bring it up to date because I think there's some modern stuff as well that's important. So the framers were very worried that elections could be corrupted. They could be corrupted in a variety of different ways, and they spent a lot of time trying to design an election system that wouldn't be subject to that kind of corruption. And there are a number of different provisions in the Constitution that deal with the kinds of corruption they were worried about. Two that I'd just like to highlight here because I think they go to this idea about the national interest and foreign governments are one that seems today, I think, to most of us to be really a kind of remnant of a past time, which is if you become an American citizen, almost everything in this country is open to you. You can become Chief Justice of the United States. You can become Secretary of State. But the one office that's not open to you, even though you're a citizen just like all of the rest of us, is the presidency because of the natural-born citizen clause of the Constitution. And the reason they put that in is they were so worried about foreign influence over a president. The other clause, which, probably no one had heard of 5 years ago, but now everybody talks about is the Emoluments Clause. They were really worried that the president, because he was only going to be in office for a little while, would use it to get everything he could, and he would take gifts from foreign countries, not even necessarily bribes, but just gifts, and they were worried about that as well. So they were very concerned about those elections. But it's not just them, and I want to say something about what our national interest is today, because our national interest today is different in some important ways than it was in 1789. What the framers were worried about was that we would be a weak country and we could be exploited by foreign countries. Now, we're a strong power now, the strongest power in the world. We can still be exploited by foreign countries. But the other thing that we've done And this is one of the things that I think we as Americans should be proudest of, is we have become what John Winthrop said in his sermon in 1640 and what Ronald Reagan said in his final address to the country as he left office. We have become the shining city on a hill. We have become the nation that leads the world in understanding what democracy is. And one of the things we understand most profoundly is it's not a real democracy. It's not a mature democracy if the party in power uses the criminal process to go after its enemies. And I think you heard testimony, the Intelligence Committee heard testimony about how it isn't just our national interest in protecting our own elections. It's not just our national interest in making sure that the Ukraine remains strong and on the front line so they fight the Russians there and we don't have to fight them here. But it's also our national interest in promoting democracy worldwide. And if we look hypocritical about this, if we look like we're asking other countries to interfere in our election, if we look like we're asking other countries to engage in criminal investigations of our president's political opponents, then we're not doing our job of promoting our national interest in being that shining city on a hill.
Professor Feldman, anything to add?
Ultimately, the reason that the Constitution provided for impeachment was to anticipate a situation like the one that is before you today. The framers were not prophets, but they were very smart people with a very sophisticated understanding of human incentives. And they understood that a president would be motivated naturally to try to use the tremendous power of office to gain personal advantage, to keep himself in office, to corrupt the electoral process, and potentially to subvert the national interest. The facts strongly suggest that this is what President Trump has done, and under those circumstances, the framers would expect the House of Representatives to take action in the form of impeachment.
Professor Feldman, did you review the Intelligence Committee report finding that President Trump compromised national security to advance his personal political interests?
I did.
And will you explain, in your view, how that happened?
The president sought personal gain and advantage by soliciting the announcement of investigations, and presumably investigations, from Ukraine. And to do so, he withheld critical assistance that the government of Ukraine needed. And by doing so, he undermined the national security interest of the United States in helping Ukraine, our ally, in a war that it is fighting against Russia. So in the simplest possible terms, the president put his personal gain ahead of the national security interest as expressed, according to the evidence before you, by the entirety of a unanimous national security community.
Sir, is it your view that the framers would conclude that there was a betrayal of the national interest or national security by President Trump on these facts?
In my view, if the framers were aware that a president of the United States had put his personal gain and interest ahead of the national security of the United States by conditioning aid to a crucial ally that's in the midst of a war on investigations aimed at his own personal gain, they would certainly conclude that that was an abuse of the office of the presidency, and they would conclude that that conduct was impeachable under the Constitution.
Professor Gerhart, what are your thoughts on the abuse of power, betrayal of national security or national interest, and the corruption of elections, sir?
Well, I have a lot of thoughts. One of them is that what we haven't mentioned yet or brought into this conversation is the fact that the impeachment power requires this committee, this House, to be able to investigate presidential misconduct. And if a president can block an investigation, undermine it, stop it, then the impeachment power itself, as a check against misconduct, is undermined completely.
Professor Carlin, can you have an impeachable offense of abuse of power that is supported by considerations of a president's betrayal of the national interest or national security and by corruption of elections?
Yes, you can.
And do we have that here, ma'am?
Based on the evidence that I've seen, which is reviewing the transcripts of the 12 witnesses who testified, looking at the call readout, looking at some of the president's other statements, looking at the statement by Mr. Mulvaney and the like, yes, we do.
And Professor Feldman, do you agree?
Yes.
Professor Gerhart?
Yes, I do.
Professor Carlin, we've been talking about the category of other high crimes and misdemeanors, like abuse of power. But there are some additional high crimes and misdemeanors that are specifically identified in the text of the Constitution, correct?
Yes, that's true.
What are they?
Treason and bribery.
Do President Trump's demands on Ukraine also establish the high crime of bribery?
Yes, they do.
Can you explain why, please?
Sure. So the high crime or misdemeanor of bribery, I think it's important to distinguish that from whatever the U.S. Code calls bribery today. And the reason for this, in part, is because
Thank you.
in 1789, when the framers were writing the Constitution, there was no federal criminal code. The first bribery statutes that the United States Congress passed would not have reached a president at all, because the first one was just about customs officials. And the second one was only about judges. So it wasn't until, 60 years or so after the Constitution was ratified that we had any federal crime of bribery at all. So when they say explicitly in the Constitution that the president can be impeached and removed from office for bribery, they weren't referring to a statute. And I will say, I'm not an expert on substantive federal criminal law. All I will say here is the bribery statute is a very complicated statute. So what they were thinking about was bribery as it was understood in the 18th century, based on the common law up until that point. And that understanding was an understanding that someone, and generally even then it was mostly talking about a judge. It wasn't talking about a president, because there was no president before that. It wasn't talking about the king, because the king could do no wrong. But what they were understanding then was the idea that when you took private benefits, or when you asked for private benefits, in return for an official act, or somebody gave them to you to influence an official act, that was bribery.
And so we have constitutional bribery here, the high crime and misdemeanor of constitutional bribery against President Trump.
If you conclude that he asked for the investigation of Vice President Biden and his son for political reasons, that is, to aid his reelection, then yes, you have bribery here.
And informing that opinion, did you review the memorandum of the president's telephone call with the Ukrainian president, the one where President Trump asked, I would like you to do us a favor, though, and also asked about looking into his U.S. political opponents?
Yes, I did rely on that.
And did you consider the following testimony from our ambassador to the European Union, Ambassador Sondland?
Was there a quid pro quo? As I testified previously, with regard to the requested White House call and the White House meeting, the answer is yes. Everyone was in the loop.
Did you consider that, Professor?
I did consider that, yes.
And did you also consider the findings of fact that the Intelligence Committee made, including that, and I quote from finding of fact number 5, the president withheld official acts of value to Ukraine and conditioned their fulfillment on actions by Ukraine that would benefit his personal political interests?
I did rely on that. In addition, because as I've already testified, I read the witnesses, the transcripts of all of the witnesses and the like. I relied on testimony from Ambassador Sondland and testimony from Mr. Morrison, testimony from Lieutenant Colonel Vindman, testimony for Ambassador Taylor. I relied on the fact that when, I think it was Ambassador Taylor, but I may be getting which one of these people wrong, sent the cable that said, you know, it's crazy to hold this up based on domestic political concern. No one wrote back and said, that's not why we're doing it. I relied on what Mr. Mulvaney said in his press conference. So there were, you know, there's a lot to suggest here that this is about political benefit. And if I don't know if I can talk about another piece of Ambassador Sondland's testimony now, or I should wait. Tell me.
Please talk about it.
So I want to just point to what I consider to be the most striking example of this, and the most, you know, I spent all of Thanksgiving vacation sitting there reading these transcripts. I didn't, you know, I ate like a turkey that came to us in the mail that was already cooked because I was spending my time doing this. And the most chilling line for me of the entire process was the following. Ambassador Sondland said he had to announce the investigations. He's talking about President Zelensky. He had to announce the investigations. He didn't actually have to do them, as I understood it. And then he said, I never heard, Mr. Goldman, anyone say that the investigations had to start or had to be completed. The only thing I heard from Mr. Giuliani or otherwise was they had to be announced in some form. And what I took that to mean was this was not about whether Vice President Biden actually committed corruption or not. This was about injuring somebody who the president thinks of as a particularly hard opponent. And that's for his private beliefs. Because if I can say one last thing about the interests of the United States, the Constitution of the United States does not care whether the next president of the United States is Donald J. Trump or any one of the Democrats or anybody running on a third party. The Constitution is indifferent to that. What the Constitution cares about is that we have free elections. And so it is only in the president's interest, is not the national interest, that a particular president be elected or be defeated at the next election. The Constitution is indifferent to that.
Professor Feldman, any thoughts on the subject of the high crime and misdemeanor of bribery and the evidence that Professor Carlin laid out?
The clear sense of bribery at the time when the framers adopted this language in the Constitution was that bribery existed under the Constitution when the president corruptly asked for or received something of value to him from someone who could be affected by his official office. So if the House of Representatives and the members of this committee were to determine that getting the investigations either announced or undertaken was a thing of value to President Trump, and that that was what he sought, then this committee and this House could safely conclude that the president had committed bribery under the Constitution.
Professor Gerhart, what is your view?
I, of course, agree with Professor Carlin and Professor Feldman. And I just want to stress that if what we're talking about is not impeachable, then nothing is impeachable. This is precisely the misconduct that the framers created a Constitution, including impeachment, to protect against. And if there's no action, if Congress concludes they're going to give a pass to the president here, as Professor Carlin suggested earlier, every other president will say, okay, then I can do the same thing, and the boundaries will just evaporate. And those boundaries are set up by the Constitution, and we may be witnessing, unfortunately, their erosion. And that is a danger to all of us.
And what can this committee and the House of Representatives do, sir, to defend those boundaries and to protect against that erosion?
Precisely what you're doing.
Does it matter? I'll ask all the panelists. Does it matter to impeachment that the $391 million, U.S. taxpayer dollars, in military assistance that the president withheld was ultimately delivered? Professor Feldman, does that matter to the question of impeachment?
No, it does not. If the President of the United States attempts to abuse his office, that is a complete impeachable offense. The possibility that the President might get caught in the process of attempting to abuse his office and then not be able to pull it off does not undercut in any way the impeachability of the act. If you'll pardon a comparison, President Nixon was subject to articles of impeachment preferred by this committee for attempting to cover up the Watergate break-in. The fact that President Nixon was not ultimately successful in covering up the break-in was not grounds for not impeaching him. The attempt itself is the impeachable act.
Professor Carlin, does it matter to impeachment that the unfounded investigations the president sought were ultimately never announced?
No, it doesn't. And if I could give an example that I think shows why soliciting is enough. Imagine that you were pulled over for speeding by a police officer, and the officer comes up to the window and says, "You were speeding, but if you give me $20, I'll drop the ticket." And you look in your wallet and you say to the officer, I don't have the $20. And the officer says, "Okay, well, just go ahead, have a nice day." The officer would still be guilty of soliciting a bribe there, even though he ultimately let you off without your paying. Soliciting itself is the impeachable offense, regardless whether the other person comes up with it. So imagine that the president had said, "Will you do us a favor? Will you investigate Joe Biden?" And the president of Ukraine said, "You know what? No, I won't, because we've already looked into this and it's totally baseless." The president would still have committed an impeachable act, even if he had been refused right there on the phone. So I don't see why the ultimate decision has anything to do with the president's impeachable conduct.
What's the danger if Congress does not respond to that attempt?
Well, we've already seen a little bit of it, which is he gets out on the White House lawn and says, "China, I think you should investigate Joe Biden."
Professor Gerhart, your view?
I certainly would agree with what's been said. One of the things to understand from the history of impeachment is everybody who's impeached has failed. They failed to get what they wanted. And what they wanted was not just to do what they did, but to get away with it. And the point of impeachment is, it's made possible through investigation, is to catch that person, charge that person, and ultimately remove that person from office. But impeachments are always focusing on somebody who didn't quite get as far as they wanted to. It's as if, nobody's better than Professor Carlin at hypotheticals, but I'll dare to raise yet another one. Imagine a bank robbery, and the police come, and the person's in the middle of bank robbery, and the person then drops the money and says, I'm going to leave without the money. Everybody understands that's robbery. I mean, that's burglary. I'll get it right. Yeah. And in this situation, we've got somebody really caught in the middle of it, and that doesn't excuse the person from the consequences.
Professors, we've talked about abuse of power and bribery. When we started, we said we would also discuss obstruction of Congress. So I'd like to ask you some questions about obstruction of Congress. Professor Gerhart, in your view, is there enough evidence here to charge President Trump with the high crime and misdemeanor of obstruction of Congress?
I think there's more than enough. As I mentioned in my statement, just to really underscore this, the third article of impeachment approved by the House Judiciary Committee against President Nixon charged him with misconduct because he had failed to comply with 4 legislative subpoenas. Here it is far more than 4 that this president has failed to comply with, and he's ordered the executive branch as well not to cooperate with Congress. Those, together with a lot of other evidence, suggest obstruction of Congress.
Professor Carlin, do you agree?
I'm a scholar of the law of democracy. So as a citizen, I agree with what Professor Gerhart said. As an expert, my limitation is that I'm a scholar of the law of democracy. I'm not a scholar of obstruction of justice or obstruction of Congress.
We will accept your opinion as a citizen. Professor Feldman.
The obstruction of Congress is a problem because it undermines the basic principle of the Constitution. If you're going to have 3 branches of government, each of the branches has to be able to do its job. The job of the House is to investigate impeachment and to impeach. A president who says, as this president did say, I will not cooperate in any way, shape, or form with your process, robs a coordinate branch of government. He robs the House of Representatives of its basic constitutional power of impeachment. When you add to that the fact that the same president says, my Department of Justice cannot charge me with a crime, the president puts himself above the law when he says he will not cooperate in an impeachment inquiry. I don't think it's possible to emphasize this strongly enough. A president who will not cooperate in an impeachment inquiry is putting himself above the law. Now, putting yourself above the law as president is the core of an impeachable offense, because if the president could not be impeached for that, he would, in fact, not be responsible to anybody.
And, sir, in forming your opinion, did you review these statements from President Trump?
Well, we're fighting all the subpoenas. Then I have an Article 2 where I have the right to do whatever I want as president.
I did, and as someone who cares about the Constitution, the second of those in particular struck a kind of horror in me.
And Professor Gerhart, informing your opinion that President Trump has committed the impeachable offense of obstruction of Congress, did you consider the Intelligence Committee report and its findings, including finding 9, that President Trump ordered and implemented a campaign to conceal his conduct from the public and to frustrate and obstruct the House of Representatives impeachment inquiry?
I read that report last night after I had submitted my statement, but I had watched and read all the other transcripts that were available. The report that was issued reinforces everything else that came before it, so yes.
So, we've talked first about abuse of power and bribery, and then about obstruction of Congress. And Professor Gerhart, I'd like to now ask you some questions about a third impeachable offense, and that is obstruction of justice. Sir, have you formed an opinion as to whether President Trump committed the impeachable offense of obstruction of justice?
Yes, I have.
And what is your opinion, sir?
Well, based on, I've come here like every other witness, assuming the facts that have been put together in official reports. The Mueller report cites a number of facts that indicate the President of the United States obstructed justice, and that's an impeachable offense.
And in your testimony, sir, you pointed out that the Mueller report found at least 5 instances of the President's obstruction of the Justice Department's criminal investigation into Russian interference in the 2016 election, correct?
Yes, sir.
And the first of those instances was the President's ordering his then White House counsel, Don McGahn, to fire the special counsel, rather to have the special counsel fired, in order to thwart the investigation of the President, correct?
That is correct.
And the second was the President ordering Mr. McGahn to create a false written record denying that the President had ordered him to have Mr. Mueller removed.
That's correct.
And you also point to the meeting of the President with his former campaign manager, Corey Lewandowski, in order to get him to take steps to have the investigation curtailed, right?
Yes, sir, I did.
And you also point to pardon dangling and witness tampering as to Paul Manafort and Michael Cohen, former campaign official, former personal lawyer of the President.
Both individually and collectively, these are evidence of obstruction of justice.
How serious is that evidence of obstruction of justice, sir?
It is quite serious, and that's not all of it, of course. We know, as you've mentioned before and others have mentioned, obstruction of justice has been recognized as an impeachable offense, both against President Clinton and President Nixon. This evidence that's been put forward by Mr. Mueller, that's in the public record, is very strong evidence of obstruction of justice.
Professor Carlin, when you look at the Department of Justice Russia investigation and how the President responded to that, and when you look at Congress Ukraine investigation and how the President responded to that, do you see a pattern?
Yes, I see a pattern in which the President's views about the propriety of foreign governments intervening in our election process are the antithesis of what our framers were committed to. Our framers were committed to the idea that we as Americans decide our elections. We don't want foreign interference in those elections, and the reason we don't want foreign interference in those elections is because we're a self-determining democracy. And if I could just read one quotation to you that I think is helpful in understanding this, it's somebody who's pointing to what he calls a straightforward principle. It is fundamental to the definition of our national political community that foreign citizens do not have a constitutional right to participate in and thus may be excluded from activities of democratic self-government. And the person who wrote those words is now Justice Brett Kavanaugh in upholding the constitutionality of a federal statute that denies foreign citizens the right to participate in our elections by spending money on electioneering or by giving money to PACs. They have long been forbidden to give contributions to candidates. And the reason for that is because that denies us our right to self-government. And then now Justice Brett Kavanaugh was so correct in seeing this that the Supreme Court, which, as you know, has taken campaign finance case after campaign finance case to talk about the First Amendment, summarily affirmed here. That is, they didn't even need to hear argument to know that it's constitutional to keep foreigners out of our election process.
Professor Feldman, you were somewhat of an impeachment skeptic at the time of the release of the Mueller report, were you not?
I was.
What's changed for you, sir?
What changed for me was the revelation of the July 25th call and then the evidence that emerged subsequently of the President of the United States, in a format where he was heard by others and now known to the whole public, openly abused his office by seeking a personal advantage in order to get himself reelected and act against the national security of the United States. And that is precisely the situation that the framers anticipated. It's very unusual for the framers' predictions to come true that precisely, and when they do, we have to ask ourselves, someday we will no longer be alive, and we'll go wherever it is we go, the good place or the other place, and we may meet there, Madison and Hamilton, and they will ask us, when the President of the United States acted to corrupt the structure of the Republic, what did you do? And our answer to that question must be that we followed the guidance of the framers, and it must be that if the evidence supports that conclusion, that the House of Representatives moves to impeach him.
Thank you. I yield my time back to the chairman.
And my time has expired. I yield back. Before I recognize the ranking member for his first round of questions, the committee will stand in a 10-minute humanitarian recess. I ask everyone in the room to please remain seated and quiet while the witnesses exit the room. I also want to announce to those in the audience that you may not be guaranteed your seat if you leave the hearing room at this time. Good luck. And once the witnesses have left the hearing room, at this time the committee will stand in a short recess. committee will come back to order after the recess. The chair now recognizes the ranking member for his first round of questions. Pursuant to House Resolution 660, the ranking member or his counsel have 45 minutes to question the witnesses. The ranking member.
Thank you, Mr. Chairman. Before I begin on the questioning, I do want to revisit a comment that was made earlier by you, Mr. Chairman. It was our demand for a minority hearing day, and you stated you would rule on it later. I just wanted to remind you the rules of the House do not permit a ruling on this. They do not permit a vote, and you cannot shut it down. And according to your own words, the minority is entitled to day of hearings. It's a right rarely exercised, but it guards against the majority abusing its power to exclude competing views. Call it the fair and balanced rule. It's not the chairman's right to determine whether we deserve a hearing. It's not the chairman's right to decide whether prior hearings were sufficient. It's not the chairman's right to decide whether or what we say or think is acceptable. It is certainly never the chairman's right to violate the rules in order to interfere with our right to conduct a hearing. And I just commend Mr. Sensenbrenner for bringing that forward and look forward to that scheduled, that you getting that scheduled expeditiously. Moving on. Interesting part, now we hit phase 2. You've had one side, and I have to say it was eloquently argued by not only the council and by the witnesses involved, but there is always a phase 2. A phase 2 is what is problematic here. Because as I said in my opening statement, this is would be, and for many, one of the most disputed impeachments on just the facts themselves. What was interesting is we actually showed videos of witnesses. In fact, one of them was an opening statement again, I believe, which again, the closest thing to perfect outside your resume this side of heaven is an opening statement because it's unchallenged. And I agree with that, and it should be. And we've had great witnesses here today to talk about this. But we didn't talk about anything about Kurt Volker, who said nothing about it. We said nothing about the aid being held up. Morrison, who contradicted Vindman and others. We've not done that, and I don't expect the majority to, because that's not what they're here for. They're not here to give exculpatory evidence, just like the Schiff report gives nothing of exculpatory evidence. And also there's still evidence being withheld by Adam Schiff that has not come to this committee, and we've still not got any of the underlying stuff that came from that investigation that, according to House H660, we believe we're supposed to get. One being the very important part is the Inspector General, the IC Inspector General, his testimony is still being held. And there's a, quote, secret on it, or they're holding it in classification. Last time I checked, we have plenty of places in this building and other buildings to handle classified information if they still want to do that. But it's being withheld from us. I have to believe now there is a reason it's being withheld, because undoubtedly there's a problem with it, and we'll just have to see as that goes forward. So anybody in the media, anybody watching today, the first 45 minutes and we went through, have painted a very interesting picture. It's painted an interesting picture that goes back many, many years. It paints an interesting picture of picking and choosing which part of the last few weeks we want to talk about, and that's fine because we'll have the rest of the day to go about this. But Professor Turley, you're now well rested. And you got one question you were asked a yes, no on and not given to elaborate, but I'm going to start here. Let's just do this. Elaborate, if you would, because you tried to, on the question that was asked to you. And then if there's anything else that you've heard this morning that you would disagree with or have an emphasis on, I will go ahead and allow you some time to talk. By the way, just for the information, Mr. Chairman, this is the coldest hearing room in the world. And also, for those of you who are worried about I'm uncomfortable, upset, I'm happy as a lark, but this chair is terrible. I mean, it is amazing. But Mr. Turley, go ahead.
Well, it's a challenge to think of anything I was not able to cover in my robust exchange with Majority Counsel, but I'd like to try.
Go right ahead.
There's a couple of things I just wanted to highlight. I'm not going to take a great deal of time. I respect my colleagues. I know all of them, and I consider them friends. And I certainly respect what they have said today. We have fundamental disagreements. And I'd like to start with the issue of bribery. This statement has been made, not just by these witnesses, but Chairman Schiff and others, that this is a clear case of bribery. It's not. And Chairman Schiff said that it might not fit today's definition of bribery, but it would fit the definition back in the 18th century. Now, putting aside Mr. Schiff's turn towards originalism, I think that it might come as a relief to him and his supporters that his career will be a short one, that there is not an originalist future in that argument. The bribery theory being put forward is as flawed in the 18th century as it is in this century. The statement that was made by one of my esteemed colleagues is that bribery really wasn't defined until much later. There was no bribery statute, and that is certainly true. But it obviously had a meaning. That's why they put it in this important standard. Bribery was not this overarching concept that Chairman Schiff indicated. Quite to the contrary, the original standard was treason and bribery. That led Mason to object that it was too narrow. If bribery could include any time you did anything for personal interest instead of public interest, if you have this overarching definition, that exchange would have been completely useless. The framers didn't disagree with Mason's view that bribery was too narrow. What they disagreed with was when he suggested maladministration to add to the standard, because he wanted it to be broader. And what James Madison said is that that's too broad, that would essentially create what you might call a vote of no confidence in England. It would basically allow Congress to toss out a president that they did not like. But once again, we're all channeling the intent of the framers, and that's always a dangerous thing to do. The only more dangerous spot to stand in is between Congress and an impeachment as an academic. But I would offer instead the words of the framers themselves. You see, in that exchange, they didn't just say bribery was too narrow. They actually gave an example of bribery. And it was nothing like what was described. When the objection was made by Madison, ultimately the framers agreed. And then Morris, who was referred to earlier, did say we need to adopt this standard. But what was left out was what came afterwards. What Morris said is that we need to protect against bribery because we don't want anything like what happened with Louis XIV and Charles II. That is, the example he gave of bribery was accepting actual money as the head of state. So what had happened in that example that Morris gave as his example of bribery was that Louis XIV, who was a bit of a recidivist when it came to bribes, gave Charles II a huge amount of money, as well as other benefits, including apparently a French mistress, in exchange for the secret treaty of Dover of 1670. It also was an exchange for his converting to Catholicism. But that wasn't some broad notion of bribery. It was actually quite narrow. So I don't think that dog will hunt in the 18th century, and I don't think it'll hunt today. Because if you take a look at the 21st century, bribery is well defined. And you shouldn't just take our word for it. You should look to how it's defined by the United States Supreme Court. In a case called McDonald versus the United States, the Supreme Court looked at a public corruption bribery case. This was a case where gifts were actually received, benefits were actually extended. There was completion. This was not some hypothetical of a crime that was not fulfilled or an action that was not actually taken. The Supreme Court unanimously overturned that conviction, unanimously. And what they said was that you cannot take the bribery crime and use what they called a boundless interpretation. All the justices said that it's a dangerous thing to take a crime like bribery and apply a boundless interpretation. They rejected the notion, for example, that bribery could be used in terms of setting up meetings and other types of things that occur in the course of a public service career. So what I would caution the committee is that these crimes have meaning. It gives me no joy to disagree with my colleagues here, and I really don't have a dog in this fight. But you can't accuse a president of bribery, and then when some of us note that the Supreme Court has rejected your type of boundless interpretation, say, well, it's just impeachment. We really don't have to prove the elements. That's a favorite mantra that is sort of close enough for jazz. Well, this isn't improvisational jazz. Close enough is not good enough. If you're going to accuse a president of bribery, you need to make it stick, because you're trying to remove a duly elected president of the United States. Now, it's unfair to accuse someone of a crime, and when others say, well, those interpretations you're using to define the crime are not valid, and to say they don't have to be valid, because this is impeachment. That has not been the standard historically. My testimony lays out the criminal allegations in the previous impeachments. Those were not just proven crimes, they were accepted crimes. That is, even the Democrats on the Judiciary Committee agreed that Bill Clinton had committed perjury. That's on the record, and a federal judge later said it was perjury. In the case of Nixon, the crimes were established. No one seriously disagreed with those crimes. Now, Johnson's the outlier because Johnson was a trapdoor crime. They basically created a crime knowing that Johnson wanted to replace Secretary of War Stanton. And Johnson did, because they had serious trouble in the cabinet. So they created a trapdoor crime, waited for him to fire the Secretary of War, and then they impeached him. But there's no question he committed the crime. It's just the underlying statute was unconstitutional. So I would caution you not only about bribery, but also obstruction. I'm sorry, Ranking Member, you?
No, you're doing a good job. Go ahead.
Okay. I'd also caution you about obstruction. Obstruction is a crime also with meaning. It has elements. It has controlling case authority. The record does not establish obstruction in this case. That is, what my esteemed colleague said was certainly true. If you accept all of their presumptions, it would be obstruction. But impeachments have to be based on proof, not presumptions. That's the problem when you move towards impeachment on this abbreviated schedule that has not been explained to me. Why you want to set the record for the fastest impeachment. Fast is not good for impeachment. Narrow, fast impeachments have failed. Just ask Johnson. So the obstruction issue is an example of this problem. And here's my concern. The theory being put forward is that President Trump obstructed Congress by not turning over material requested by the committee. Okay? And citations have been made to the third article of the Nixon impeachment. Now, first of all, I want to confess, I've been a critic of the third article of the Nixon impeachment my whole life. My hair catches on fire every time someone mentions the third article. Why? Because you would be replicating one of the worst articles written on impeachment. Here's the reason why. Peter Rodino's position as chairman of Judiciary was that Congress alone decides what information may be given to it. Alone. His position was that the courts have no role in this. And so, by that theory, any refusal by a president based on executive privilege or immunities would be the basis of impeachment. That is essentially the theory that's being replicated today. President Trump has gone to Congress, to the courts. He's allowed to do that. We have 3 branches, not 2. I happen to agree with some of your criticism about President Trump, including that earlier quote where my colleagues talked about his saying that there's this Article 2, and he gives this overriding interpretation. I share that criticism. You're doing the same thing with Article 1. You're saying Article 1 gives us complete authority that when we demand information from another branch, it must be turned over or we'll impeach you in record time. Now, making that worse is that you have such a short investigation. It's a perfect storm. You set an incredibly short period, demand a huge amount of information, and when the president goes to court, you then impeach him. Now, does that track with what you've heard about impeachment? Does that track with the rule of law that we talked about? So, on obstruction, I would encourage you to think about this. In Nixon, it did go to the courts, and Nixon lost. And that was the reason Nixon resigned. He resigned a few days after the Supreme Court ruled against him in that critical case. But in that case, the court recognized there are executive privilege arguments that can be made. It didn't say, you had no right coming to us, don't darken our doorstep again. It said, we've heard your arguments, we've heard Congress's arguments, and you know what? You lose. Turn over the material to Congress. Do you know what that did for the judiciary is it gave this body legitimacy. It wasn't the Rodino extreme position that only you decide what information can be produced. Now, recently, there are some rulings against President Trump, including a ruling involving Don McGahn. Mr. Chairman, I testified in front of you a few months ago, and if you recall, we had an exchange, and I encouraged you to bring those actions. And I said I thought you would win, and you did. And I think it was an important win for this committee because I don't agree with President Trump's argument in that case. But that's an example of what can happen if you actually subpoena witnesses and go to court. Then you have an obstruction case because a court issues an order. And unless they stay that order by a higher court, you have obstruction. But I can't emphasize this enough, and I'll say it just one more time. If you impeach a president, if you make a high crime and misdemeanor out of going to the courts, it is an abuse of power. It's your abuse of power. You're doing precisely what you're criticizing the president for doing. We have a third branch that deals with conflicts of the other two branches. And what comes out of there and what you do with it is the very definition of legitimacy.
Let's continue on. Let's unpack what you've been talking about. First of all, the McDonald case, how was that decided? Was that a very split court? Were they really torn about that? That case came out how?
Yeah, it came out unanimous. So did a couple of the other cases I cite in my testimony, which also refute these criminal theories.
One of the things that you said also, and I think it could be summed up, and I use it sometimes, just what's the layman's language here, is facts don't matter. And that's what I heard a lot of in the 45 minutes. Well, the facts said this, or the facts are disputed this, but if this, if that, if this, it rises to an impeachment level. And that was sort of what you're saying, that crimes, I think your word was, crimes have meanings. And I think this is the concern that I have. Is there a concern that if we just say it up that facts don't matter, that we're also, as you've said, abusing our power as we go forward here and actually looking at what people would actually deem as an impeachable offense?
I think so, and part of the problem is that to bring a couple of these articles, you have to contradict the position of President Obama. President Obama withheld evidence from Congress in Fast and Furious, an investigation, a rather moronic program, that led to the death of a federal agent. President Obama gave a sweeping argument that he was not only not going to give evidence to this body, but that a court had absolutely no role in determining whether he could withhold the evidence.
Mr. Turley, I have a question on that, because you brought up Mr. Obama, you brought up other presidents in this process. Is there not an obligation by the office of the president, we'll just use that term, not to be Obama, Trump, Clinton, anyway, isn't there an obligation by the president to actually assert the constitutional privileges or authorities that have been given or when accused of something, or crime or anything else?
Yeah, I think that President Obama has invoked too broadly. But on the other hand, he has actually released a lot of information. I've been friends with Bill Barr for a long time. We disagree on executive privilege. I'm a Madisonian scholar. I tend to favor Congress in disputes. And he is the inverse. His natural default is Article 2. My natural default is Article 1. But he actually has released more privileged information than any Attorney General in my lifetime, including the Mueller report. These transcripts of these calls would be core executive privilege material. There's no question about that.
And I think that's something that is, again, not pointed out when you're doing a back and forth like we're doing. The transcript of the call release, the things that have been released to the Muellers, we go back through this, there has been, work in progress by this administration. I think the interesting point that I want to talk about is two things. Number one, Congress's abuse of its own power, which has not been discussed here, even internally, where we have had committees not willing to let members see transcripts, not being willing to give those up under the guise of impeachment, or you shouldn't be able to see them, although the rules of the House were never invoked to stop that. What we're seeing here, and I want to hit something else before we move on to something else, is the timing issue that you've talked about here. Again, I believe we talked about this with the Mueller report. We talked about this with everything else. This is one of the fastest, we're on a train. I said this earlier. We're on a clock. The clock and the calendar are seemingly dominating this. Is irregardless of what anybody on this committee, and especially members not of this committee, to think about what we're actually seeing of fact witnesses and people moving forward. We don't have that yet. So the question becomes, is an election pending when facts are in dispute, and you made a mention of this. This is one in which the facts are not unanimous. There's not universal, there's not even bipartisan agreement on the facts and what they lead to, especially when there's exculpatory evidence that has been presented, not in the Schiff report, but in other reports. Does that timing bother you from a historical perspective, not only in the past, but moving forward as well?
Yeah, fast and narrow is not a good recipe for impeachments. That's the case with Johnson. Narrow was the case with Clinton. They tend not to survive. They tend to collapse in front of the Senate. Impeachments are like buildings. There's a ratio between your foundation and your height. And this is the highest structure you can build under the Constitution. You want to build an impeachment? You have to have a foundation broad enough to support it. This is the narrowest impeachment in history. You could argue with Johnson. Johnson, it might actually be the fastest impeachment. Johnson actually was, what happened to Johnson was actually the fourth impeachment attempt against Johnson. And actually the record goes back a year before. They laid that trapdoor a year before, so it was not as fast as it made it out, it might appear.
And again, let's go back. I want to go back to something else. And you talked about bribery, and Ms. Taylor's going to address a good bit of that. But I want to go back to something that you talked about, because it really bothers, I think, the perception out there of what's going on here in the disputed transcript. Being the call has been laid out there. The president said, "I wanted nothing for this." There's all this exculpatory evidence that was not presented in the last 45 minutes. But there is one thing that's interesting, and it's been reported in the mainstream media, and it goes back to your issue of does crimes matter, or what this definition is that House, our majority initially accused the president, and they kept saying quid pro quo, and we still hear it as we go through. But then, as reported, they used a political focus group to determine whether the phrase polled well. And apparently it didn't poll well, so they agreed to change their theory of the case to bribery. Does that not just feed into more of what you're saying about how we're actually, the crime matters and that facts do matter in a case like it, or at least should matter?
It does. There's a reason why every past impeachment has established crimes. And it's obvious. It's not that you can't impeach on a non-crime. You can. In fact, non-crimes have been part of past impeachments. It's just that they've never gone up alone or primarily as the basis of impeachment. That's the problem here. If you prove a quid pro quo, that you might have an impeachable offense. But to go up only on a non-criminal case would be the first time in history. So why is that the case? The reason is that crimes have an established definition and case law. So there's a concrete, independent body of law that assures the public that this is not just political, that this is a president who did something they could not do. You can't say the president is above the law if you then say the crimes you accuse him of really don't have to be established.
I think that's the problem right now that many members of this House, members of this body, and especially the American public are looking at, that if you say he's above the law, but then you don't define it or you define the facts to whatever you want to have, that is the ultimate railroad that everybody in this country should not be afforded. Everyone is afforded due process. Everyone is afforded the process to actually make their case heard. That's the concern that I have in this committee right now, and we've already seen it voted down that we're not going to look at certain fact witnesses. We're not even been promised other hearings in which this committee, and in the words and the concerns that echoed almost 20 years ago from the chairman, where he did not want to take the advice of another body or entity giving us, the Judiciary Committee, a report and then acting as a rubber stamp if we didn't do this. Just as a reminder, it was almost 2.5 weeks before the discussion of this kind of a hearing back then, before the hearing actually took place. These are the kind of things that, as timing goes, I think the obvious point here is that timing is becoming more of the issue because of the concern, as has been stated before, about elections. They're more concerned about trying to fit the facts in to what the president supposedly did, presumably did, and make those hypotheticals stick to the American public. The problem is their timing, the definition of crimes, the definition of the fact of bribery as defined by the Supreme Court is not making their case. It's not fitting what they need to do. The issue that we have to deal with going forward is why the rush? Why do we still not have the information from the Intelligence Committee? Why is the Inspector General's report from the IC Committee being withheld, even in a classified setting? These are the problems that you have now highlighted, and I think that need to be, and this is why the next 45 minutes and the rest of the day is going to be applicable, because both sides matters, and at the end of the day, this is a fast impeachment, the fastest we're seeing, based on disputed facts, on crimes or disturbances that are made up, with the facts to fit each part. With that, I'm going to turn it over to my counsel, Mr. Taylor.
Professor Turley, I'd like to turn to the subject of partisanship as the founders feared it and as it exists today. It's a subject Alexander Hamilton was very concerned about when it came to impeachment. He wrote some prescient words in Federalist Paper number 65. In advocating for the ratification of the Constitution, the Federalist Papers laid out the reasons Madison and principally Hamilton thought the Impeachment Clause was necessary, but he also flagged concerns. He said, in many cases of impeachment, it will connect itself with the pre-existing factions and will enlist all their animosities, partialities, influence, and interest on one side or on the other, and in such cases there will always be the greater danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. Professor Turley, do you think Hamilton predicted a real danger here of hyper-partisan impeachments?
Well, certainly that has proven to be the case. It's certainly of the two impeachments that we have seen. It's also important to note, by the way, that we often think that our times are unique. You know, this provision wasn't just written for times like ours. It was written in times like ours. That is, you know, these are people that were even more severe than the rhetoric today. I mean, you have to keep in mind, Jefferson referred to the administration of the Federalists as the reign of the witches. So this was not a period where people didn't have the strong feelings. And indeed, when people talk about, you know, members of this committee acting like they want to kill each other, back then they were actually trying to kill each other. That's what the sedition law was, is you were trying to kill people that disagreed with you. But what's notable is they didn't have a whole slew of impeachments. They knew not to do it. And I think that that's a lesson that actually can be taken from that period. That the framers created a standard that would not be endlessly fluid and flexible. That standard has kept us from impeachments despite periods in which we have really despised each other. And that, I think, is the most distressing thing for most of us today, is there's so much more rage than reason. You can't even talk about these issues without people saying, you must be in favor of the Ukrainians taking over the country, or the Russians moving into the White House. At some point, as a people, we have to have a serious discussion about the grounds to remove a duly elected president.
Professor Turley, in your testimony, you've said that when it comes to impeachment, we don't need happy ideological warriors, we need circumspect legal analysis. But let's take a quick look at the deeply partisan landscape on which this particularly partisan impeachment is being waged. I mean, the Democratic leaders pushing Trump's impeachment represent some of the most far-left urban coastal areas of the country. The bar graphs here show counties, and the height of the bars indicate total votes cast, and the color of the bars show the margin of victory for the winner in the 2016 presidential election. As you can see, the parts of the country represented by these Democrat impeachment leaders voted overwhelmingly for Hillary Clinton during the last presidential election. Also, during the 2016 presidential election, lawyer campaign contributions tilted 97% for Clinton, 3% for Trump. And the situation is essentially the same at law schools around the country, including those represented on the panel here today. Now, Professor Turley, I'd like to turn now to the partisan process that defines these impeachment proceedings. This is how the Nixon impeachment effort was described in the bipartisan 1974 staff report. You were talking about the initiation of the impeachment inquiry. It says, this action was not partisan. it was supported by the overwhelming majority of both political parties, and it was. Regarding the authorization of the Clinton impeachment inquiry, it was supported by all Republicans and 31 Democrats. Now fast forward to the current impeachment. The House Democrats' Trump impeachment drive was subsequently approved only by Democrats, and indeed it was approved over the opposition of 2 Democrats and all Republicans. Professor Turley, how does this trend comport with how the founders understood impeachment should operate?
Well, I believe that the founders certainly had aspirations that we would come together as a people, but they didn't have any delusions. It certainly was not something that they achieved in their own lifetime, although you'd be surprised that some of these framers actually did at the ends of their lives, including Jefferson and Adams, sort of reconcile. Indeed, I think one of the most weighty and significant moments in constitutional history is the one that is rarely discussed, that Adams and Jefferson reached out to each other, that they wanted to reconcile before they died. And they met, and they did. And maybe that is something that we can learn from. But I think that the greater thing I would point to is the 7 Republicans in the Johnson impeachment. If I could just read one thing to you, and everyone often talks about one of the senators, but not this one, and that's Lyman Trumbull, who was a fantastic senator. He became a great advocate for civil liberties. You have to understand that most of these senators, when it was said that they jumped into their political graves, it was true. Most of their political careers ended. They knew they would end because of the animosity of the period. Trumbull said the following. He said, once this set the example of impeaching a president for what, when the excitement of the hour shall have subsided, will be regarded as insufficient causes, no future president will be safe who happens to differ from the majority of the House and 2/3 of the Senate. He said, I tremble for the future of my country. I cannot be an instrument to produce such a result, and at the hazard of the ties, even of friendship and affection, till calmer times shall do justice to my motives, no alternatives are left to me. And he proceeded to give the vote that ended his career. You can't wait for calmer times. The time for you is now. And I would say that what Trumbull said has even more bearing today, because I believe that this is much like the Johnson impeachment. It's manufactured until you build a record. I'm not saying you can't build a record, but you can't do it like this, and you can't impeach a president like this.
Now, Professor Turley, there's a recent book on impeachment by Harvard Law professor Lawrence Tribe and Joshua Matz that discusses what they consider to be a legitimate impeachment process. The book is pretty anti-Trump. It's called To End a Presidency, and in that book, the authors state the following. When an impeachment is purely partisan, or appears that way, it is presumptively illegitimate. When only Republicans or only Democrats view the president's conduct as justifying removal, there's a strong risk that policy disagreements or partisan animus have overtaken the proper measure of congressional impartiality. Another quote is, we can also expect that opposition leaders to the president will be pushed to impeach and will suffer internal blowback if they don't. The key question is whether they will cave to this pressure. One risk of our broken politics is that the House will undertake additional doomed partisan impeachments, a development that would be disastrous for the nation as a whole. Professor Turley, is that advice being followed by House Democrats in this case?
Not on this schedule. The one thing, if you look at, I laid out the 3 impeachments, the one thing that comes out of those impeachments in terms of what bipartisan support occurred is that impeachments require a certain period of saturation and maturation. That is, the public has to catch up. I'm not prejudging what your record would show, but if you rush this impeachment, you're going to leave half the country behind. And certainly that's not what the framers wanted. You have to give the time to build a record. This isn't an impulse buy item. You're trying to remove a duly elected president of the United States, and that takes time, it takes work. But at the end, if you look at Nixon, which was the gold standard in this respect, the public did catch up. They originally did not support impeachment, but they changed their mind. You changed their mind. And so did, by the way, the courts, because you allowed these issues to be heard in the courts.
Professor Turley, the Nixon and Clinton impeachments were debated solidly in the high crimes category, correct? Crimes
Yes.
were at issue. But on the evidence presented so far, is it your view that there is no credible evidence that any crime was committed by President Trump?
Yes, I've gone through all of the crimes mentioned. They do not meet any reasonable interpretation of those crimes, and I'm relying on express statements from the federal courts. I understand that the language in the statutes are often broad. That's not the controlling language. It's the language of the interpretation of federal courts. And I think that all of those decisions stand mightily in the way of these theories. And if you can't make out those crimes, then don't call it that crime. If it doesn't matter, then what's the point? Call it treason. Call it endangered species violations if none of this matters.
So that would put the Democrats' move to impeach President Trump in the category of high misdemeanors. And in James Madison's notes of the Constitutional Convention debates, they clearly show that the term high misdemeanor was explicitly referred to as a technical term. And it wasn't just something that any majority of partisan members might happen to think it was at any given time. And often when there's a debate about a technical term, people turn to dictionaries. And the first truly comprehensive English dictionary was Samuel Johnson's A Dictionary of the English Language. It was first published in 1755. And the founders in many of their libraries had this book and on their desks. And the Supreme Court still cites Johnson's dictionary to determine the original public understanding of the words used in the Constitution. So here's how the 1785 edition of Johnson's dictionary defines the relevant terms in high misdemeanor. High, the relevant sub-definition is capital great, opposed to little, as high treason. The definition of misdemeanor is defined as something less than an atrocious crime. And atrocious is defined as wicked in a high degree, enormous, horribly criminal. So if you look at how these words were defined during the time the Constitution was debated and ratified, a misdemeanor is something less than an atrocious crime, and atrocious is wicked in a high degree, and as a result, a high misdemeanor must be something like just less than a crime that's wicked in a high degree. Now, Professor Turley, does that generally comport with your understanding of the phrase high misdemeanors that was understood by the founders with the purpose of narrowing that phrase to prevent the sorts of abuses that you've described?
It did. I mean, if you compare this to the extradition clause, the language that was used was different for a reason. They did not want to establish a type of broad meaning. According to the view of some people as to the meaning of high crimes and misdemeanors, those provisions would be essentially identical. And that's clearly not what they wanted.
Professor Turley, next I'd like to explore how this impeachment is based on no crime and no request for false information, unlike the Nixon and Clinton impeachments. I'd like to start with some background. The American media for years has been asking questions about former Vice President Biden's son and his paid involvement with the corrupt Ukrainian energy company Burisma. Here's one example of those media reports from June 2019. It was an ABC News investigation titled Hunter Biden's Foreign Deals. Did Joe Biden's son profit off father's position as vice president? There's a still clip of it here with a Burisma promotional video. And many have seen the video of Joe Biden talking about getting the Ukrainian prosecutor who was investigating Burisma fired. And a New York Times article says from May 1st, 2019, referring to Joseph R. Biden, one of his most memorable performances came on a trip to Kiev in March 2016 when he threatened to withhold $1 billion in United States loan guarantees if Ukraine's leaders did not dismiss the country's top prosecutor. Among those who had a stake in the outcome was Hunter Biden, Mr. Biden's younger son, who at the time was on the board of an energy company owned by a Ukrainian oligarch who had been in the sights of the fired prosecutor general. So even if Hunter Biden engaged in no crimes regarding his sitting on the board of Burisma, if an investigation led to the bankruptcy of the corrupt company, Hunter Biden's lucrative position on the Burisma board would have been eliminated along with his $50,000 a month payments. That was his stake in a potential prosecution involving the company. In fact, even Neil Katyal, the former acting Solicitor General under President Obama, in his recent book entitled Impeach, says the following: is what Hunter Biden did wrong? Absolutely. Hunter Biden had no real experience in the energy sector, which made him wholly unqualified to sit on the board of Burisma. The only logical reason the company could have had for appointing him was his ties to Vice President Biden. This kind of nepotism isn't only wrong, it is a potential danger to our country, since it makes it easier for foreign powers to buy influence. No politician from either party should allow a foreign power to conduct this kind of influence peddling with their family members. Also, Lieutenant Colonel Vindman was asked at his hearing, would it ever be U.S. foreign policy in your experience to ask a foreign leader to open a political investigation? And he replied, certainly the president is well within his right to do that. So the American media and others were asking questions about Hunter Biden and his involvement in the Ukraine. And President Trump, in his call with the Ukrainian president, simply asked the same questions the media was asking. Now, Professor Turley, is it your understanding that the House impeached Nixon for helping cover up his administration's involvement in a crime, and that the evidentiary record showed Nixon knew of criminal acts and sought to conceal them, including tape recordings of President Nixon ordering a cover-up of the Watergate break-in shortly after it occurred?
It is.
And is it also your understanding that the House impeached Clinton for the crime of lying under oath to deny a woman suing him for sexual harassment evidence she was legally entitled to?
That's correct.
So there were requests for false information in both the Nixon and Clinton scandals by the president's aides or associates or by the president himself, correct?
Yes.
But there are no words in the four corners of the transcript of President Trump's call that show a request for false information, are there?
No, and that's one of the reasons why, if you want to establish the opposing view, you have to investigate this further.
Now, let me walk through the standard of evidence House Democrats insisted upon during the Clinton impeachment. The minority views in the Clinton impeachment report were signed by, among others, current Senate Minority Leader Schumer and current House Judiciary Committee Chairman Nadler. And they say that one of the professors who testified, quote, has meticulously documented how in the Nixon inquiry, everyone agreed, the majority, the minority, and the President's counsel, that the standard of proof for the committee and the House was clear and convincing evidence. Professor Turley, would you agree that the evidence compiled to date by House Democrats during these current impeachment proceedings fails to meet the standard of clear and convincing evidence?
I do, by a considerable measure.
Now let me turn again to the book 10 to Presidency. In that book, the authors state the following, quote, except in the most extraordinary circumstances, impeaching with a partial or plausibly contested understanding of key facts is a bad idea. Professor Turley, do you think that impeaching in this case would constitute impeaching with a partial or plausibly contested understanding of key facts?
I think that that's clear because this is one of the thinnest records ever to go forward on impeachment. I mean, the Johnson record, once again, we can debate because that was the fourth attempt at an impeachment. But this is certainly the thinnest of a modern record. If you take a look at the size of the record of Clinton and Nixon, they were massive in comparison to this, which is almost wafer thin in comparison. And it has left doubts, not just doubts in the minds of people supporting President Trump, doubts in the minds of people like myself about what actually occurred. There's a difference between requesting investigations and a quid pro quo. You need to stick the landing on the quid pro quo. You need to get the evidence to support it. It might be out there, I don't know, but it's not in this record. I agree with my colleagues. We've all read the record, and I just come to a different conclusion. I don't see proof of a quid pro quo, no matter what my presumptions, assumptions, or bias might be.
On that point, I'd like to turn now to the current impeachment procedures. Professor Turley, would you agree that a full and fair adversary system in which each side gets to present its own evidence and witnesses is essential to the search for truth?
It is, and the interesting thing is on the English impeachment model that was rejected by the framers. They took the language, but they actually rejected the model of the impeachment from England, particularly in terms of Hastings. But even in England, it was a robust adversarial process. If you want to see adversarial work, take a look at what Edmund Burke did to Warren Hastings. I mean, he was on him like ugly on moose for the entire trial.
And as you know, in the minority views in the Clinton impeachment report, the House Democrats wrote the following. We believe it is incumbent upon the committee to provide these basic protections. As Representative Barbara Jordan observed during the Watergate inquiry, impeachment not only mandates due process, but due process quadrupled. The same minority views also support the right to cross-examination in a variety of contexts in the Clinton example. Now, Professor Turley, you describe how Monica Lewinsky wasn't allowed to be called as a witness in the Senate impeachment trial. And after her original testimony, she revealed how she had been told to lie about her relationship with President Clinton by his close associates. It's a cautionary tale about the dangers of denying key witnesses. Can you elaborate on that?
Yeah, the only reason I mentioned that is that was in the portion of my testimony dealing with how you structure these impeachments. What happened during the Clinton impeachment, and it came up during the hearing that we had previously, was a question of how much the House had to do in terms of Clinton impeachment, because you had this robust record created by the independent counsel, and they had a lot of testimony, videotapes, et cetera. So the House basically incorporated that, and the assumption was that those witnesses would be called at the Senate. But there was a failure at the Senate. The rules that were applied, in my view, were not fair. They restricted witnesses to only 3, and that's why I brought up the Lewinsky matter. About a year ago, Monica Lewinsky revealed that she had been told that if she signed that affidavit that we now know is untrue, that she would not be called as a witness. If you had actually called live witnesses, that type of information would have been part of the record.
Thank you. Mr. Chairman, I yield back.
The gentleman yields back. I note that this is the moment in which the White House would have had an opportunity to question the witnesses, but they declined our invitation. So we will now proceed to questions under the 5-minute rule. I yield myself 5 minutes for the purpose of questioning the witnesses. Professor Feldman, would you respond to Professor Turley's comments about bribery, especially about the relevance of the elements of criminal bribery?
Yes. Bribery had a clear meaning to the framers. It was when the president, using the power of his office, solicits or receives something of personal value from someone affected by his official powers. And I want to be very clear. The Constitution is law. The Constitution is the supreme law of the land. So, of course, Professor Turley is right. You wouldn't want to impeach someone who didn't violate the law. But the Constitution, the supreme law of the land, specifies bribery as a ground of impeachment, as it specifies other high crimes and misdemeanors. Bribery had a clear meaning. If the House believes that the president solicited something of value in the form of investigations or an announcement of investigations, and that he did so corruptly for personal gain, then that would constitute bribery under the meaning of the Constitution, and it would not be lawless. It would be bribery under the law.
So the Supreme Court case in McDonnell interpreting the federal bribery statute and other decisions interpreting the statutes would not be relevant?
The Constitution is the supreme law, and the Constitution specifies what bribery means. Federal statutes can't trump the Constitution. They can't defeat what's in the Constitution.
Thank you. Professor Gerhart, would you respond to Professor Turley's comments about obstruction of justice or obstruction of Congress, please?
Yes. On obstruction of justice, one thing I want to emphasize is obstruction of justice is not just about obstruction of a court. It's obstruction of any lawful proceeding. And so that obstruction isn't limited to whatever is happening on the courts. And obviously here, there are judicial proceedings going on, but there's also a really critical congressional proceeding, which brings us to obstruction of Congress. And with the obstruction of Congress, I don't think, in fact, I can say, I know there's never been anything like the president's refusal to comply with subpoenas from this body. These are lawful subpoenas. These have the force of law to them. These are the things that every other president has complied with and actually acted in alignment with, except for President Nixon in a small but significant set of materials.
Professor Turley implied that as long as the president asserts a fanciful, ultimately non-existent privilege like absolute immunity, he can't be charged with obstruction of Congress because, after all, it hasn't gone through the courts yet. Would you comment on that? Professor Gerhart?
I'm sorry, I missed part of the question. Please, I'm sorry.
Professor Turley implied that we can't charge the president with obstruction of Congress for refusing all subpoenas as long as he has any fanciful claim until the courts reject those fanciful claims.
I have to respectfully disagree. No, his refusal to comply with those subpoenas is an independent event. It's apart from the courts. It's a direct assault on the legitimacy of this inquiry, which is crucial to the exercise of this power.
Thank you, Professor Carlin. I'll give you a chance to respond, if you would like, as well, to the same question.
I wanted to respond to the first question about bribery, if I could instead, which is, although counsel for the minority read Samuel Johnson's definitions of high and crime and misdemeanor, he didn't read the definition of bribery. Now, I have the 1792 version of Johnson's dictionary. I don't have the initial one. And there, he defines bribery as the crime of giving or taking rewards for bad practices. And so if you think it's a bad practice to deny military appropriations to an ally that have been given to him, if you think it's a bad practice not to hold a meeting to buck up the legitimacy of a government that's on the front line, and you do that in return for the reward of getting help with your reelection, that's Samuel Johnson's definition of bribery.
Thank you. And Professor Feldman, if Washington were here today, if he were joined by Madison, Hamilton, and other framers, what do you believe they would say if presented with the evidence before us about President Trump's conduct?
I believe the framers would identify President Trump's conduct as exactly the kind of abuse of office, high crime and misdemeanor that they were worried about, and they would want the House of Representatives to take appropriate action and to impeach.
And they would find obstruction of justice, obstruction of Congress, and abuse of power, or some of them?
I believe that if the evidence supported those things in their minds, and if Congress determines that that is what the evidence means, then they would believe strongly that that's what Congress ought to do.
Thank you. I'll yield back my time, the balance of my time. I'll now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for 5 minutes for questioning the witnesses.
This just keeps getting more amazing. I think we just put in the jury pool the Founding Fathers and said, what would they think? I don't think we have any idea what they would think, in all due respect, with this, because of the different times, the different things we've talked about, but also to in some way insinuate on a live mic with a lot of people listening that the Founding Fathers would have found President Trump guilty is just simply malpractice in this, with these facts before us. That is just simply pandering to a camera. That is simply just not right. I mean, this is amazing. We can disagree. What's amazing on this committee is we don't even disagree on the facts. We cannot even find a fact right now where it is not going through the public testimony and also even the transcripts and all. It is not. Mr. Turley, are we going to deputize somebody between now and the founders into the jury pool here?
Well, first of all, only I will speak for James Madison. No, we all will speak for James Madison with about the same level of accuracy. It's a form of necromancy that academics do all the time, and that's what we get paid for. But I just want to note a couple things. First of all, I do find it rather surprising that you would have George Washington in this jury pool. I would strike him for cause. George Washington was the first guy to raise extreme executive privilege claims. He had a rather robust view of what a president could say. If you were going to make a case to George Washington that you could impeach over a conversation he had with another head of state, I expect his powdered hair would catch on fire. Also, I just want to know one other thing, and I am impressed with carrying an 18th century copy of Samuel Johnson with you.
No, it's just the online version.
It's just the online version. You, as an academic, I was pretty darn impressed. I just want to note one thing which may explain part of our difference. The statutes today on bribery are written broadly, just like they were back then. That was my point. The meaning of those words are subject to interpretation. They're written broadly because they don't want them to be too narrow. That was the case in the 18th century as they are today. But the idea that bad practices could be the definition of bribery, really? I mean, is that what you get from the Constitutional Convention, that bad practices? Is that why Mason wanted to put in maladministration? Because bad practices is not broad enough? This is where I disagree. Now, the other thing that I just wanted to note is, and I have so much respect for Noah, and I'm going to just disagree on this point. I feel it is a rather circular argument to say, well, the Constitution is law. Upon that, we are in agreement. But the Constitution refers to a crime. To say, well, you can't trump the Constitution because it defines the crime. It doesn't define the crime. It references the crime. Now, the examples were given during the Constitutional Convention, and those do not comport with bad practices. They comport with real bribery. But to say that the Supreme Court's decision on what constitutes bribery is somehow irrelevant is rather odd. What the Constitution contains is a reference to a crime, and then we have to decide if that crime has been committed.
And I think one of the things that came out just a second ago was also this discussion of, and we had this discussion earlier about, is it the presidential prerogative and also members of the president's cabinet to assert privileges and rights, and we talked about the fast and furious with President Obama. Remember, Attorney General Holder was held in contempt by this body for withholding and not complying with subpoenas. You just can't pick and choose history here with what you want to have. But I think also you just made a statement, and it was brought up earlier, talking about bad practice. It is also the law of the land that we are supposed to ensure that countries given aid are not corrupt. And I think this is also something that's missing from this discussion as well. If the president has had a long-seated distrust of foreign companies, especially Ukraine and others, with a history of corruption. I made this statement earlier. It's in the report from the HIPSI side on our side. 68% of those polled in the Ukraine over the previous year had bribed a public official. Ukraine had corruption issues. It came back from the Obama administration, came through the Trump administration, and our rule is that they have to actually look at the corruption before giving taxpayer dollars. The president was doing that, and now it has been blown up because we've now found in this hearing today, facts really don't matter if we're trying to fit it into a law or fitting it into a breaking of rule that we want to impeach on. And as I've said, the reason we're doing this is the train is on the track. This is a clock calendar impeachment, not a fact impeachment. I yield back.
Gentleman yields back. I now recognize Ms. Lofgren for 5 minutes.
Thank you, Mr. Chairman. This is, as has been mentioned, only the third time in modern history that the committee has assumed the grave responsibility of considering impeachment. And oddly enough, I've been present at all three. I was staff of Congressman Don Edwards during the Nixon impeachment, present on the committee during the Clinton impeachment, and here we are today. At its core, I think the impeachment power really is about the preservation of our democratic systems. And the question we must answer is whether the activity of the president threatens our Constitution and our democracy. And it's about whether he's above the law and whether he's honoring his oath of office. Now, the House Judiciary Committee staff, and it wasn't me, it was other staff, wrote an excellent report in 1974, and this is what they said. Impeachment of a president is a grave step for the nation. It is to be predicated only upon conduct seriously incompatible with either the constitutional form and principle of our government or the proper performance of constitutional duties of the presidential office. And I'd ask unanimous consent to enter the House Judiciary Committee report on constitutional grounds into the record. Thank you, Mr. Chairman. Like President Nixon, the allegations against President Trump involve serious election-related misconduct. Nixon's associates burglarized the DNC headquarters to give him a leg up in his election. Nixon tried to cover up the crime by obstructing federal and congressional investigations. He also abused his powers to target his political rivals. And here, we're confronted with evidence suggesting that President Trump tried to leverage appropriated military assistance to resist Russia by Ukraine to convince a foreign ally to announce an investigation of his political rival. Professor Carlin, I'd like you to tell me your view on how President Trump's conduct, meeting his request of the foreign ally to announce an investigation of his adversary, how does that compare to what President Nixon did?
Not favorably. Because as I suggested in my opening testimony, it was a kind of doubling down because President Nixon abused domestic law enforcement to go after his political opponents. And what President Trump has done, based on the evidence that we've seen so far, is he's asked a foreign country to do that, which means it's not. It's sort of like a daily double, if you will, of problems.
Professor Gerhart, do you have an additional comment on that?
I certainly would agree with Professor Carlin. Yes, I think the difficulty here is we need to remember that impeachable offenses don't have to be criminal offenses, as you well know. And so what we're talking about is an abuse of power. And we're talking about an abuse of power that only the president can commit. And there was a systematic, concerted effort by the president to remove people that would somehow obstruct or block his ability to put that pressure on Ukraine to get an announcement of an investigation. That seems to be what he cared about. Just the mere announcement, and that pressure was going to produce the outcome he wanted until the whistleblower put a light on it.
I want to go back quickly to something Professor Turley said. As we saw in the Myers case, and I was a member of the committee when we tried to get her testimony, as well as the Fast and Furious case, which also was wrongfully withheld from the Congress, litigation to enforce congressional subpoenas can extend well beyond the terms of the presidency itself. That happened in both of those cases. Professor Feldman, is it, as Professor Turley seemed to suggest, an abuse of our power not to go to the courts before using our sole power of impeachment in your judgment?
Certainly not. Under the Constitution, the House is entitled to impeach. That's its power. It doesn't have to ask permission from anybody, and it doesn't have to go through any judicial process involving the judicial branch of government. That is your decision based on your judgment.
Thank you. I'd just like to note that this is not a proceeding that I looked forward to. It's not an occasion for joy. It's one of solemn obligation. I hope and believe that every member of this committee is listening, keeping an open mind, and hoping that we honor our obligations carefully and honestly. And with that, I yield back, Mr. Chairman.
The gentlelady yields back. The gentlelady yields back. We are expecting votes on the House floor shortly, so we will recess until immediately after the conclusion of those votes. I ask everyone in the room to please remain seated and quiet while the witnesses exit the room. I want to remind members of the audience that you may not be guaranteed your seat if you leave the hearing room at this time. At this time, the committee will stand in recess until immediately after the votes.